Welcome to Alley Top Files. We are still here. I'm sorry, where's my camera? We are still here. I literally just woke up. I'm having my coffee. I'm so exhausted. I don't know if you are.
I am too. It has been a long week, but it has
One
been,
more day,
yeah,
one more night. I love that song.
it's a good song.
Yeah. Everybody says they love my thumbnail. Thank you. I had to go with that. Like, what else can you go with? Um, Ali, I just sent you an opaque overlay. Transition of the rifles absolutely not the same. Yes, I have heard this going on X. Was it you that posted it? Who posted that? The scope is different, right? I'm trying to catch up with all this stuff. I can't show I can't show rifles on here. I had to edit all that out yesterday. Um a little coffee, yes. A little coffee is gonna go with some fed slop today. Because I think we're just gonna get the same again.
Oh, most definitely.
Uh I posted it on your last X post. Okay. Which I really haven't been looking at it this morning because I just woke up. uh, which one? Which X post, I wonder? Which one? Which one? Oh, there it is. I see. Oh, are you Tootie? You're Tootie in tracksuit. I'm so tired I can't even see. I showed your video. Thank you so much for coming here. I showed your video of the SUV. I mean, not the SUV, the Challenger yesterday. Thank you so much for coming. I'm looking at it right now. Oh, the end pieces too? Oh, I wish I could show this. We're not allowed to show rifles here. Okay, I'll repost that. You know, this is the crap that we're going through now. The scope is different too. Did you see that? We're just talking about the weapon they found, with the towel. So nicely. It's like you're carrying the baby. So nicely we're going to take this rifle, we're going to place it in the grass, and we're going to wait for someone to pick it up. It's so great. It's such a beautiful thing how they do it. I think okay. I think all this twigs crap is a load of crap. I think that this is what they wanted because Andrew Colvett, I have to play his video from yesterday. I didn't get a chance to finish it. He just he like wants twigs to be like, maybe it could be twigs, like we don't know, like we gotta ask these questions. You want to ask questions now? Didn't we talk about this yesterday with the Andrew Colvett video? So, no, Andrew, we're not doing that. No, Blake Neff, you're not allowed to come on X Spaces and start asking questions or answering questions now and geofence us and try to do all that stuff to us, get our information. No, 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 no. I think all these drawings that he was doing, it looks like it's the low seas center and it's the Korea. It's all fed slop. It's all made up. That's my opinion. I feel that it's all. If you guys haven't seen Lance Twig's drawings and stuff, I think it's just all fake. They want you. They want you to think in the beginning it's Tyler, and then it switches to Twigs, and then they go, "Well, you know who it is. Could be Lance now." And then the whole case is thrown out. I mean, I don't know what's happening here. I'm not going with drawings. That's first of all. That is not going to be even entered into evidence. His drawing. Do you guys know what I'm talking about by his drawings? First of all, I gotta repost this rifle thing. Second of all, I'm talking about. I'll bring it up though. Are they starting yet? No. I'll bring it up though. They're like this stuff. And there's one that looks like he mapped out. I'll bring it up on break, but it looks like he mapped out. I don't know. Oh wow, is that Erica's tattoo right there? Hi, hi. Is that your tattoo? Yeah, it could be. It's like this. I okay. Ray, I can't do this. Don't bring the drawings in now. Okay? Does anybody know what I'm talking about with drawings? Hello, everybody. You're just tuning in. Um, I don't think he even looks like the person in the stairwell. People are saying that it's Lance Twig. No, no. I can tell you, even if it's grainy, that's not him. It's not either one of them. Oh. Why is the thing burnt? Like, why is the note burnt? Who burnt it? Who burnt the note? I know everybody's posting about his drawings. Guys, this is such slop if I've ever seen it. It's like they want they who's Turkey Tom? Head slop. Sloppity slop. Lop lop lop. Who's Turkey Tom? Substack posting all those pictures. Like I seen all this back in like I don't know October or whatever. I seen all this stuff. I go, I'm not even gonna go touch this Ty Robinson and Lance Twiggs. I already knew that they were just like going to be nothing, but they're going to focus on them, right? Because this is where we are. And they're not going to bring all that into evidence because but they need that probably. Will they bring it? I don't know. Who blew out the flame on the note so that some of it survived? I think it's all rigged allegedly. It really bothers me. The notes. His drawings, that whole that table with all the electrical stuff. I'll bring it up on the stage for they're going to be running late again, aren't they? I can feel it. Let's do a poll. Should I do like will Erica leave crying on the last day? Let's do that for fun. I'm so sorry, guys. I am so freaking tired. You gotta get a picture of Erica crying. Come on. Okay. And then I'm going to show you some of the drawings. Paint. Oh my God, Ray, I can't talk. Paint me like one of your French girls, Jack. I'm not doing this today. Can you guys hear me okay? Everybody? Okay. They're going to be late again. I can feel it. Feeling it. And I'm absorbing it. Flippity frick. Yes. Turkey Tom. Turkey Tom. If anybody doesn't know who Turkey Tom is, it's the one that put out all his drawings. Okay. Yeah, I'm not into it, but I will bring it up on stage. What else will I bring up? Ugh, the freaking note. I can bring up the note. I can bring up that. Oh. Oh, yeah, and I want to bring up the Colvet video too because I didn't get a chance to finish it. Yeah, so everybody knows who Turkey Tom is. I don't know. It was on Substack. His apparently he said he was their friend. Yeah, you just randomly happen to have all his like drawings. Okay, I'm gonna say drawings. I'm coming out. Do, 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 do. They want it to be like okay, what they want it to be Twigs handwriting. This is what they want. Like even Andrew Colvet is saying some weird shady stuff on TikTok. I think this is their plan. Tricky Tom in a letter of trial that was shown looks the same. Yeah, that's what they want. I'm just not buying it. I'm not buying any of this. Any of it. They probably Tyler and Lance probably know the Farnsworth and they probably know everybody. They're probably best friends with everybody. I mean, at this point, Lance Twiggs is a Mormon. He's in that community. I don't really know too much about him, but I know that I feel like for me that they're gonna have him in. I hope he goes on the stand. Hope can they switch that, Cindy? Like, how about if they gave him immunity? Can they flip it? Can they flip that? Can they flip that switch? Can we get the parents? Like Baron, did you watch Baron's show yesterday? Wow. If you're not watching Baron's show every night for a recap on all this stuff. And also like Valhalla's and Trigger Smart, Mr. Lecco. Everybody's doing great work. Billy and Brandy are at Utah. Teresa's in Utah. A lot of people are there. Brandy and Teresa, Better Life, came on for a little bit yesterday. They must be exhausted. I think they lined up again and still they slept. They slept in the line. Yeah. So they only allow 14 people in there. Excuse me. They're running late, eh? Of course. Here we go again on my own. Okay. I might have to go get some Kleenex because it's not happening right now. Okay, so you guys like my thumbnail, eh? Like that? This is what we're at. Tell me if it comes on because I'm waiting for this court stuff. I'm gonna start loading some things in here. Did it go in? Oh, there they are. Import. Okay. So, I forgot what her name is on X, but her name is Break the Echo Chamber. She posted some of this stuff. Break the Echo Chamber. Now, we all seen this before, Turkey Tom. We've seen this before. It's like he's drawing the courtyard or something. Okay. That's cool. It feels kind of sloppy. Just like the hats and the backpacks. Feels sloppy to me. Yeah, we gotta get something else on Lance. We gotta get some drawings in there. We have to build something in order to know that they're connected in this. So get him to scribble some drawings. Okay. All right. We'll get him to scribble some drawings. And once we scribble some drawings, we'll put it there, and we'll get Turkey Tom will release it. Turkey Tom will release it. Oh my god, I feel like I've been watching too much Coach Colin. Oh man. Too much Coach Colin. Talking to myself. Yeah, this stuff. Okay. So she circled so shout out to Break the Echo Chamber. This is her on X. I reposted her. But I mean, she's just going with the note thing and the lettering. I love Coach Colin. He'll start talking, right? And I just did that now without even realizing that I've been watching too much Coach Colin. Yeah. I mean, this is it. Bed slop. We gotta Turkey. Who's Turkey Tom? On Substack, guys. So apparently this is Lance Twig's drawings. That's cool. And then hold on. Let me see if I can bring up. Are they live yet? No. Okay. Keeping an eye on that. They're not live yet. They're running late, guys. They're running late. Per usual. And so I'm gonna get the note now. I can show you. And then bring up the burnt note. You like how they have that one little piece on the burnt note? It's just one little tiny piece left. It's so weird. That's why I say he's sloppy. Very sloppy. Okay, so this is the note, right? And this is Lance Twig's drawings. So that's so that the S's and the M's are the same. Yeah, the M's and the S's. Something like that. And we got the burnt note, like how we have that one little piece there. Just that one little piece left. Wouldn't that whole thing just be it's paper? I don't know what's going on here. Is it on yet? I can't see. Okay, there we go. Court is not in session. It is late. Good morning, everybody that just joined. What am I looking for? Oh, I didn't get a chance to play the Andrew Colvett video. I did not get a chance to play that. Okay. I'm going to keep an eye on the court. Day 5. Will Erica Kirk be crying? They have to get it on film at some point. Got to go out with a bang. The cigars and brandies. So let's go. Let's go. Oh, this is it. This is it.
I've been dealing with so many crazy accusations, either leveled at Erica or myself or the organization or whatever, anything except for Tyler Robinson in this process, that I haven't gotten a chance to articulate clearly what questions I still have outstanding that I want answers to. So here we go. Who knew?
You have questions? Oh, they're starting. Every time I play this video, they stop it. Oh.
Please enter your appearances.
Chad Grunander, Ryan McBride, Lauren Hunt, David Sturgill for the state, and the County Attorney Jeff Gray and Chris Ballard are also here.
Good morning.
Good morning, Your Honor. Kathy Nestor, Richard Novak, Stacy Visser, and Michael Berg here for Mr. Robinson, who's seated in the
Finally.
Good morning.
Good morning.
Mr. Robinson, good morning to you. And for the record, the court also recognizes the presence of victim representative Ms. Erica Kirk. Ms. Kirk, Good morning to you as well. First, with respect to courtroom protocol, to maintain security and decorum, any individual that exits the courtroom during proceedings will not be permitted to re-enter until recess. After recess, all counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. Second, the court will address the camera operator and the still photographer. If both of you could please approach the lectern. The court's purpose in this dialogue is to ensure clarity regarding the expectations governing today's proceedings. Could you both please state your roles for today's hearing?
My role is to capture pool photography, still photos.
My role is for video in accordance with the court decorum order.
And I apologize. Would you mind putting your names on the record?
Tess Crowley.
Megan Thackeray with KSL.
Thank you. Have you both reviewed the court's standing decorum order?
Yes.
Yes.
Do you understand the requirements set forth in that order as it applies to your activities today?
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
Do you anticipate any difficulty complying with the order?
No.
All right. Thank you both. Before we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. Cell phones are not permitted in the courtroom unless expressly authorized. Any unauthorized possession or use of a cell phone or electronic device in the courtroom may be addressed by the court. For those individuals who have a cell phone, I invite you to join me as I silence my cell phone to ensure that the proceedings today can proceed without distraction. The court also expects every person in attendance will be treated with the dignity and respect to which they are entitled. Consistent with this court's standing decorum order, all spectators shall remain quiet, civil, and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or of other visible reactions during the hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or in opposition to any person connected with this case or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, and orderly, and faithful to the rights and dignity of every person involved. All right. My understanding is the parties wish to address an issue before we get started. Is that correct?
We may.
Mr. Novak.
Thank you, Your Honor, and good morning. I passed up to the court after providing copies of it to counsel for the state and counsel for the media, a single piece of paper. Does the court have that?
I do. Thank you, Mr. Novak.
Thank you, Your Honor. So every morning, this court has a colloquy with the camera operators about their ability to comply with this court's orders. And they acknowledge that they understand the order and that they can comply with it. And the court asks them if they have any problem with it. And they state to the court that they do not have a problem with it. We also spent many, many, many hours of court time addressing which exhibits will and will not be published through the electronic media. And this exhibit, the court ordered would not be published through the electronic media, and it was. And without belaboring the point, the court can imagine our concern that the media and the state who control this exhibit and the publication of this exhibit in the courtroom as per the court's orders failed to comply with this court's orders after all of the effort that we made and the court made to make sure that the court balanced everybody's rights, including the rights that we're concerned about, which are Mr. Robinson's. No doubt the counsel for the media and counsel for the state will say that it was a very, very brief mistake, that it was corrected as soon as they realized the error, but it's done. It's out there, it's photographed. I'm informed secondhand that if I want to buy this image and maybe even have it framed and put behind museum quality glass, I can do so and put it up in my office. Obviously, I'm not going to do that. But my point is, it doesn't matter how long the court's order was violated. When we live in an electronic world, it's done and it's permanent. And we just wanted the record to be clear that we're concerned that the court's orders have been violated, and they've been violated with respect to an order that was specifically designed to protect Mr. Robinson's right to a fair trial. And I don't want to belabor the point any further. I'm also not going to refer to the exhibit with any more specificity because it's not necessary.
Is there a requested remedy or potential sanction that you feel is warranted given the actions which you have outlined this morning?
I think that we would like to think, when I say we, I mean Mr. Robinson's counsel, about that. We have, as the court knows, repeatedly asked this court, moved this court, not to have electronic broadcast of this proceeding, of any of the proceedings, and specifically this proceeding. The court denied those motions and overruled our objections to the specific EMC requests. So I think it's a little premature, but I can represent to the court that we will suggest a remedy in advance of the next hearing.
Well, Mr. Novak, I appreciate that, but I would ask that if it is something that is concerning, that it be addressed immediately. So I'm not going to wait until this. I recognize and appreciate what you have described, and this was on my mind a lot last night as well.
Okay.
I don't want to sit on this. So I ask you respectfully to confer with your counsel and come up with that, because I want to address it. I agree. It is concerning and it warrants examination and to be addressed immediately, especially as we have a little bit left of our preliminary hearing. So I want to give it the weight it is needed, and I don't disagree with you.
Then why don't we beg the court's indulgence? We don't need to empty the courtroom. We can go talk about what we think an appropriate measured sanction would be. And we can bring that suggestion back to the court in a few minutes.
All right. Well, before we do that, I want to turn to the state and to the media to address what you've addressed. And then obviously if there's a part two, then therefore.
And I appreciate the invitation. And I also appreciate the court's desire to address the consequences, if any, immediately.
Thank you, Mr.
I was
Novak.
not trying to delay it. I just think it's an issue which warrants some thought. The court has said it gave it some thought. We will have a suggestion very briefly.
Thank you. Turning to the state.
Thank you, Your Honor. I think at the outset, it's important to recognize that everyone's doing their best here. The court is, I know the clerks are, I think the media is, we certainly are, and the defense is. This issue came up in the context of an examination of a witness. One exhibit was published before the exhibit at issue. was also brought onto the screen. I explained what we were going to do, and then the exhibit was brought onto the screen. I reviewed the video last night. The camera captured this for approximately 2 seconds. The camera operator, I think, acting in diligence and appropriateness, immediately panned as soon as she realized that there was a new exhibit on the screen. The court took it down, and as soon as they realized that an exhibit was on the screen, I immediately instructed my paralegal to take it down, and it was. Defense, I think everyone involved here made quick and appropriate efforts as soon as they realized a mistake had been made to remedy and mitigate that issue. As I explained what I was what we were going to do, defense counsel did not object as that happened. And the reason I bring that up is because of the requirement for timely objections. Moreover, I do want to say this exhibit was read into the record. It was allowed to be read into the record earlier. It is also in an earlier pleading, which is the information. This portion of that exhibit, I understand, is in the information. And it is largely cumulative of Exhibit 16 and 16.1, which were previously admitted into evidence and published to the media. Finally, we are going to be dealing with a lot of publicity when it comes to media coverage. And I think that's really where the remedy is going to be addressed. I understand there may be a remedy that can be fashioned today to prevent this kind of thing going forward or going on in the future in this hearing. But I think ultimately that's where this will be addressed. Any other questions from me, Your Honor?
Well, not at this time. I will afford you the opportunity, obviously, to respond when the defense comes back. I want to weigh this and taking in consideration, and I find your representations to be accurate as to what occurred. I believe that I noticed it and asked for it to be taken down because I have a live stream on my screen for that very purpose. And the sequence, I believe I made note, and if I'm wrong, please correct me. It's been a long 4 past days, but that's the only addition that I find to the representation. And certainly, Mr. Novak, feel free to correct it if you believe the sequence was any different. I just want to make sure a clear record is being made of what happened in order for whatever happens next to be appropriate and proportional to the actions that occurred.
No, and that's consistent with my memory. And I also reviewed the video, the live stream as well in preparation for this issue today. So that's exactly what I think happened. From my perspective, examining the witness, I did not have a view of what was being published to the public and the media. And so I think the court immediately, as soon as it recognized that, brought that to everyone's attention.
Thank you, Mr. McBride. To the media.
Good morning, Your Honor.
Good morning.
Appreciate the opportunity to be here to speak on behalf of the media. I think our understanding of what happened is consistent with what both the defense and the state have said here. So I don't want to belabor that point. But here's how I understand them. There's 2 exhibits at issue. Those exhibits were used yesterday in part because the juxtaposition of those 2 exhibits might have provided some sort of benefit to the court. The first of those exhibits was asked to be published through all 3 of the court's phases. The court said it will be admitted into evidence, be shown in the courtroom, will not be shown on the cameras. That happened about 3 hours into the hearing. That all went smoothly and well. That operated exactly as it is intended to. That requires the participation of everyone, the court, the defense, the state, media, camera operator, all to do that well. Later in the day, when in the video I reviewed, this was about 5 hours into the runtime yesterday. The second exhibit that was going to be compared side by side was introduced. That also went through that 3-step process. In that case, the court said that that could be admitted into evidence, shown to the court, and then also shown on the cameras. So it was put on the courtroom cameras. At that point, there was what I think is a useful practice by the camera operator to wait a beat, because sometimes mistakes do happen, right? In that case, though, that was authorized. So the camera then panned to the screen, which is set up specifically for the camera operator to be able to capture that. Examination on that exhibit began. Then, because the examination seemed to call for that juxtaposition, without much warning for anyone involved, the previous exhibit that was intended to be juxtaposed was placed on the screen. From, I think, a observer's view who didn't know where the testimony was going without warning. The camera operator, I think quite astutely, within seconds, recognized this is a different exhibit, and recalling the court's prior order, recognized I should pan off, and did within seconds. I think at the time that was happening, the court also caught that and said, let's not do that. Now, and that was the end of it. I think the 2 seconds is about right. I don't want to minimize that. I understand the point that Mr. Novak is making. We are operating in some ways on high wire, and we are trying to place as many nets as we can, and all the parties are working together to try to do that. But in the age in which we live, one of the challenges is that sometimes when something like that is placed on a live stream, someone can screenshot it, and like Mr. Novak said, if they want to put that for sale on the internet, then they can. That's why working together to ensure that even small mistakes like that don't happen is critical. And the media has the media coalition that are given the opportunity and the benefit of being able to be here to run cameras and to take photographs have complete buy-in on that point. There are, of course, people out there watching a live stream that are not part of our coalition that we can't control. And that's why it's so important that we get these pieces right. I do want, without going too far into the evidence, to note not only that several lines of this exhibit are available publicly in the information, but that the full text, every word of that exhibit is contained in a search warrant, in this case, that was initially filed on September 17th. This is in the 4th District, but in a different court. Was held for 6 months, as search warrants often are. But then on March 16th, March 17th, was released in full. On page 7 of that search warrant is the full text of this exhibit. I don't want to suggest that anybody gets the right to say, well, I think it's public. The court has said don't show it in the screen, but since I think it is, we'll just come back later on and tell the court it's not a big deal because it's already public. That's not how it works. If we say we think it's in the public, the court says, I understand that, but I'm going to make an order. That order should be adhered to. But I do, for the purposes of prejudice, for potential remedy, for the court's concern and the court's sleepless nights, I do want the court to know that as well. And members of our coalition have pointed out to me as we've talked about this, while we take this very seriously, it is true in this case that the full text of that, not the image of the exhibit itself, but the full text is already in the public sphere, has been reported on, and is out there. I only want to reinforce, to close, the recognition that the media, our coalition, I, as an attorney for that coalition, have an obligation to make sure that mistakes don't get made. And in this case, even though I believe that the camera operator didn't act in violation of the court's decorum order, didn't do something that was forbidden by that there was an order that said, don't publish this exhibit. And because it flashed on the screen when the camera operator was filming that screen, that did happen. The media is fully bought in. I, as one of the attorneys and the other attorneys for the media coalition, are fully bought in on a goal to make sure that this kind of thing doesn't happen. Of course, I understand Mr. Novak and the defense's need to make a record and make an objection. And I also recognize and appreciate and understand the court's role in trying to make sure it imposes whatever sort of direction, caution.
I said the same thing. Let's go. Come on.
Is needed to
Let's
make
go.
sure that
Move
its
it.
orders
Move in or move
are,
out.
Recognized and adhered to. I want the court to know that we will understand that and will comply with whatever it is that the court orders.
Hurry up. Let's go.
Anything further before we break? Mr. Novak?
We don't need a break.
Okay. Well,
The court wants a break.
I want to review this. I'm sure there is a stream out there. I want to look at it again in order to appreciate the full effect and exposure. I remember it, but given the nature of this and trying to weigh the constitutional rights of all parties, I want to be thorough and look at it exactly. So as we move forward, as I evaluate what's being requested by the parties, that I am at the level of knowledge and because what it is, it was on screen. I want to look at it, how long, what exactly was on screen, and in order to be at the point of saying, okay, I fully understand. I mean, I was here, I saw it, I noticed it on the screen, but again, I want to take that extra 2 minutes to review that.
I'm not suggesting that we rush through this at all. I just wanted the court to understand that our request for the remedy and the sanction, we are prepared to share that with the court, but we can certainly wait until the court has had an opportunity to review whatever the court thinks it needs to review. The permanence of this violation of the court order is a different issue from how long it took to correct the violation. It's a permanent consequence. In other words, that image is out there forever and ever in violation of the court's order, no matter what actions the court, the state, and the media took to remedy it, because that's the technological world we live in. So that's my response, if I may, to the arguments. But we can hold our suggestion until the court's ready for it.
All right. If the parties feel it'd be helpful to confer while the court is reviewing it, you may, just so that if you choose to, I encourage it. If you don't, I respect that. A court's going to take about 5 minutes. Again, I just want to review it, to be brought up to full speed and just to have it freshly in my mind.
I'm going to make one more point, if I may, and that is, this is not the first time that this has happened. We had earlier proceedings in this case
And they ended court yesterday.
where the cameras depicted images inside the courtroom that the court had prohibited, and the court imposed certain consequences on the media as a result of that. And so that's just something to keep in mind, in my opinion, if I may. Thank you.
All right, before the court takes a 5-minute recess and to review this, does any party need the benefit of the record based off the dialogue between me and Mr. Novak? All right, not seeing any party respond. The court's in recess. We'll come back at 9:45. Court is in a brief recess.
What is going on here? Didn't we discuss this yesterday? I
Yes,
thought we were already over this. I thought it was something new.
I did too, but apparently not.
Asking Tornado Alley, am I missing something here? Why are we like first thing in the morning talking about what we talked about yesterday?
Yeah, I thought the judge specifically stayed late to make sure that this was all discussed already and handled. That way it wasn't a problem today.
You just said it. So what is this now? Somebody's
no
mad.
idea.
Somebody's mad.
This is so weird.
So is this what they're referring to?
Is it in the live updates?
The internet screenshot of this stuff?
Quick as fuck too. Sorry, excuse my language, but
no,
they were
man.
quick with it.
You just say whatever you want to say. Like I think even Barron showed my burnt note pic. I sent it out right away. I'm like, okay,
As you should.
I had to put
Tornado Alley said bring her up.
Okay. Did I send her a link? I'm coming out. I want the world to see. Okay, hold on.
Wisha said he said this wasn't the first time. What else did they show that they weren't supposed to?
Yeah,
Good
like
question.
I'm thinking that it's not the note, it's something else.
Right. Yeah.
I'm just that's why I'm so confused this morning. What is this?
Did they have evidence shown before court started or something? Or like what? Because
I don't know.
the live updates.
I thought it was this. I thought they dealt with this before it ended yesterday, like you said, right?
Yeah.
And that's why I'm confused. So I'll bring up Tornado Alley. Like this is what I'm thinking. Like I'm thinking it's this the note. The
What a
burnt note.
shit show.
Yeah, and the note itself. They don't want us to see the handwriting. But it's all slop anyways.
Right.
It's all sloppy stuff.
What did Barron say about the handwriting? I seen Barron's post about it yesterday.
What did who say? Barron?
Yeah, Barron said, I would assume a guy in the top 1% of ACT college entrance exam test scores in a perfect 4.0 GPA would know how to use commas.
Yes.
Hey.
Hi.
How are you guys this morning? I know, Allie, you're tired.
I woke up like maybe I sent Ray the link, and then I woke up right then, and I'm just maybe half an hour before. So yeah, I'm tired.
Yeah. No, I mean they did actually. I don't know. Yesterday was probably tough for a lot of people to watch stuff like this because it was just like
emotional.
Half the day was about this issue, and determining how they were going to go about, navigating, and balancing
Yeah.
this issue, right? And
this is the problem, this thing, right?
Yes. So this is what leaked out, by accident, and I'm not sure if she mentioned there was something else too. I'd be curious what
We're
else
all
leaked
wondering.
out.
Yeah, no, we're all wondering that.
I don't
He
know if I
said
caught
this
it.
wasn't the first time. So I'm just referencing what they were saying. He said this wasn't the first time. What else did they show? They weren't supposed to. There was something on a day 2 or day 3. There was
Yeah.
the audio, they were playing the audio of Charlie in the background. So this
That's
is
right.
now the second time something has been released without, they didn't. I could hear it.
Yeah, right. So, I mean, and this was brought up at the very end of the day, and they were going to address it again. I don't know if you remember, but Graf said that at the very end of the day. He's like, look, I'm not saying this is going to come up tomorrow. Like, so he'd already kind of set that and knew that was going to happen. So that's why they're addressing it now. And it's like, it doesn't matter. Like I said in the comments earlier, it's like, it doesn't matter if it's 1 millisecond or 5 minutes. Like in a digital world where, however many people are recording this and live streaming, like you're going to catch it, and people know how to hit pause and take screenshots. Like, so it doesn't matter. And so this is a big concern,
You're
this
literally live streaming it.
Yes.
Literally.
So like a whole
This was
case.
it right here. This was it. And they swiped the screen right away.
Mhm.
As soon as they brought up this thing, they went, whoopsie. I want to show the burnt note, but I didn't want to show that.
Right.
So we're not supposed to have this.
So how did it burn? Who burnt it?
Right. Supposedly Lance Twiggs burnt it, right? That's the official story, is he burnt it.
It's so
And
sloppy.
yeah. So anyways, it is a big deal, and that's why Graf is readdressing it, because like it could ruin the whole case, like because
note?
Damn.
No, because of information that shouldn't be out. Like, I mean, I think there's ways that the defense could argue that this case should be thrown out for. I don't know. Baron would probably know more, and I'd probably need to do some research. But like in my head, I feel like there's some things that could happen. Like it's the integrity of the case. It's a really big deal. So as boring and long-winded as it may be, like it is a really important thing to settle and to figure out.
Do you think he wrote that? I don't think he wrote that.
I don't think so either.
I don't think he wrote that.
Yeah,
I think that's what
he definitely
TPUSA
didn't.
wants. I think TPUSA wants, the Twigs part of this thing coming in now. They're all getting involved now. Mr. Andrew Kovac. Go to his TikTok. Look at the stuff that he's posting. I still haven't had a chance. Oh, they're coming back now. I'll read the super chat right away. Maybe deep dive. Thank you, Elizabeth. Be done into invite Zoom meeting, and Allie and her crew get many shadows. I've lost count of Flamingo Mafia, baby. Let's go. I'm doing the members on Saturday. Let me just remove this so we can watch what's happening here. I don't know whose head is that? What in the world of the greasy hole or what? Oh
No.
Oh my God, the poor, whose head is that? I'm sorry. I wouldn't. Okay. Cameraman. Cameraman, get that off that head right now. Oh my god.
What is camera guy doing?
Oh my god. I can
I bet the
see his
cameraman
freaking-
isn't even there right now. Like I bet he
Oh my
stepped
God.
away and this dude stepped in front of the camera. Oh no.
I can see his scalp. Oh my god, his scalp. His scalp. Hold on a second.
You
Let
see
me
the
get a clear.
dandruff. Oh my
Let me see if I
god.
can see that up close. I can't do this anymore. Now he's showing the floor. Is that the ceiling? Oh,
It's a feeling. I think he panned up.
what a weirdo. Oh my god.
We should take
Now
bets
we know
on
why
whose
everything
head that
out.
is.
We know why everything is out. We're showing scalps. We're showing hair. Oh my god. We're showing scalp, ceilings, hair, forehead, sweat. That's what's happening.
Dude.
You're right there.
Is she ready to go?
Oh, did you see that, guys? He looks sweaty. Yeah, I know. Who was that? Was that the defense?
I have no idea.
I don't even know whose head that was, guys. I'm sorry. You had to see that close.
Let's take bets on it.
Pardon?
Put a poll up. Whose head was that? Make it fun.
Well, if we can't show evidence, we'll show you dirty hair. It could have been Tyler. I don't know. I don't know.
Oh, I don't think it looked like
Looked older.
Yeah,
Well, I
looked
don't know.
older.
I think it's in the back. Like somebody just went in front of the camera, like
Mhm.
go sit down, and then they stopped right in front of the camera.
Yeah. What's your poll doing right now? Do people think
Oh,
Erica's gonna?
I just did a crying poll, just for fun. What do we got? What poll? What we got? Will Erica leave crying on the last day? I want to know if she's gonna be leaving crying, and I want to know if they're gonna catch it on camera. That's what I want to know. I think they're coming back soon. Everybody vote. Everybody vote. And if there's a poll that you want me to put up, let me know. I usually put funny polls up. But if you want like a serious poll, something serious, tell me what to write, what question you want me to.
Will do.
But Tornado Alley, I thought we dealt with this last night.
Well, okay, so they dealt with it until the issue came up, and then it had to be readdressed, and so that's why we're talking about it again.
Yeah.
Also, Erica, like they were pushing hard last night to get more released, and he was like, it's not that I don't, care about the victims. Like I do want you to have the facts, but he was also just like, at the end of the day, you have everything you need. Like the lawyers have it. This is all about show. And he pretty much called them out on it and was like, we can talk about it again tomorrow, but I'm moving on today. That's what he was so pissed yesterday.
So if I was the judge too, I'd be like, okay, you're gonna bring this up again. Okay, we're gonna take a recess. No, we don't need a recess. Oh yes, we do. Yes, he's probably spanking them in the chambers. I've had enough of you.
Mm-hmm.
Yeah, he's probably yelling at them.
Right, man. It was a crazy day. I mean, I think did anybody catch Barron last night? He really broke it down.
I caught a little bit of it.
I
had
did
to
too.
rewatch it again because I was so tired.
Yeah.
I caught like up to. Oh, he was talking. It was a long one. He was talking about where was I at? I didn't even get to the part where you told me that he showed the note and he shouted me out. And I'm like, thank you, Barron.
You gotta let that out.
I'm not even at that part yet, so I just maybe I gotta I do this a lot. I'll rewind him and I'll have to listen again.
Mm,
But no, I haven't even get a chance to listen to the whole thing. I don't know where I stopped at. Oh, because Chris called me, so then I
yeah.
stopped it, and then I think Wisha called me, and then you called me or you messaged me. So
Yeah,
then I stopped.
we chatted. Yeah.
Then I stopped. Then I stopped the show, right? And then
Right.
I forget what I'm doing, and then I'm doing something else, and then I go over here, and then I go to the backyard, then I go to the front, and then I go, wasn't I watching something? Oh yeah.
Yeah.
And then I'm preparing for a show, and
But the
then me
fact
and
that
Wisha were going over the Turkey Tom thing, the pictures, how sloppy. Now, if you watch Coach Colin yesterday, he talks about the Turkey Tom. If you watch him, I watch him when I take a shower, and it's not like that. I like to watch. I like to watch Coach Colin. I think he's freaking hilarious and funny. So he talks about the. I think Daisy was in his chat in his
yeah.
live. So he was talking about the drawings, and then he goes, I know, Baron talked about this before. Daisy's in the chat. What does she think? And she wrote slop. So the drawings, like, I always thought that it was just so scripted and put out at a weird time. And Turkey Tom is what?
Baron did a great coverage of the Turkey Tom
Yeah,
stuff a long
yeah,
time ago.
long time
So
ago.
yeah.
And that's why
And
coach was going like, this is like, what is this stuff? Now we got a note, we got a burnt note. This is so ridiculous.
yeah,
Just
and
lazy.
I remember when Turkey Tom came out, I was watching that and I screenshotted everything and was like trying to figure it out. And then
That's what
like
they want. They
and then
want
I was
you to
like,
get
this
in the
is
hole.
weird. I'm like, no, this is weird. Like I just knew immediately, like after I was like looking into this, I was like, this is very Fed sloppy. I don't know. It just didn't resonate. It didn't feel right. And I just stopped digging into that. And then Baron had done his analysis of it. And I was like, okay, I knew something was not
Yeah.
right. And he explained it very well. So
And what we're talking about, guys, is the excuse me, like these drawings, this Turkey Tom put it out. Who's Turkey Tom? We feel allegedly he's a sloppy person. The F slop, if you know what a F slop is. But this is what they're talking about today. Like, this is what got out. Not this. They want to show this. I think it was this. This is what they didn't want out. But they want to make it a big deal now. Because they're gonna put Lance Twiggs in the picture. You know what I mean? This is what TPUSA want. Coach is the GOAT. He truly is. He makes me laugh. I like how he's just talking to himself and then he starts impersonating different people. It's so hilarious.
Coach is a very funny guy. I don't get to catch him very much just because I'm always busy in the morning, and then evening we get all the updates from Baron and you and Candace, and so I don't watch him a lot, but he is so funny.
So Oren from Hawaii, how are you in Hawaii? Shaloha. He's saying the miss is identical to M and the S. Yes. But that's what they want. It's just my opinion. I know what you're talking about. I see it. I see. So we're going like that, and then we're going we're going from there to here. So there, okay. Supposedly this is Lance's stuff put out by Turkey Tom. And then this was shown yesterday. And they don't want you to like compare, but it is very similar. So just to bring everybody up to speed here.
Holy hell.
Yeah, the M and the S. I know, I'm on it, guys. But it's still sloppy to me, Ray. It's still sloppy. I feel like it's just so like scripted. And we didn't get a chance to watch I'm still watching to see if they're But Mr. Colvett, let's listen to him. Because he's all about this now. He's asking questions now. After how many? Look, even Frank Turek, they're all asking questions now, talking about this now. Just stop it.
Andrew
Stop.
Colvett spoke
Just
out.
stop.
My take on the whole speaking out now is they're trying to spin a new narrative because now
Not
that it's
working.
looking like it's not Tyler Robinson, they have to come up with something else.
Right.
Yeah. Yeah.
And they're trying to pin it on Lance Twiggs now.
Yeah. But this
But
is what. But this was the
I
whole
just
plan.
don't believe that to be true. I mean, do I think there's involvement? It's starting to look like, or it has looked like that for a while, but now we're starting to get some real evidence that could indicate he did have some involvement, but I still just don't think that's the full answer. You know what I mean? But that's an opinion.
Okay, I'm gonna play him now. Is that okay? Because I didn't get a chance because
That'd
court
be
started.
great.
All right.
That's right. There is a lot of indication online that other people knew something was going to happen
God,
that
they're
day on
starting
September
again.
10th.
Every time I show this, no wait, they're not starting. Hold on. Okay. Jeez, every time I play this, I see they're starting. There's a head in the way. Okay, I'll just keep going.
There is a lot of indication online that other people knew something was going to happen that day on September 10th. They posted on social media about it in really, really creepy ways. And none of those people have been held accountable. And I want to know why and what did they know and when. Another question I want to know the answer to is, was Lance Twiggs more involved than we currently know, right? We know that he's been given limited immunity for his.
Why are you asking this now? Like Barron said, he played this. I don't know if it was yesterday or the day before. But why are you asking this now? Now you're asking this?
His testimony. Right. It's going to be video testimony in the preliminary hearing. But how much did he know? And how much did he radicalize Tyler Robinson? It seems, and I encourage everybody to go check it out, there's a Turkey Tom YouTube video where one of their friends that would hang out with them in their apartment.
What the hell?
This is why I never got a chance to play the whole thing. Every time I try to play the whole thing, I sent this to Wish. I'm like, did you guys hear this? This is on his
TikTok.
Yeah, I encourage you to go to Turkey Tom. I encourage you. I ain't going anywhere.
Wow.
I'm not going anywhere where you're telling me where to go. I'm not going to check it out.
Word.
So now I know the note's fake. Now I know you're fake. I know all this fake, allegedly. This is just the vibe. Like I have this, I don't know. A lot of people think that I have this psychic ability, but I don't. I'm not. But I just don't feel it.
You're intuitive. You're intuitive, Allie.
Thank you. There's something wrong.
Mm-hmm.
He's encouraging us to go to the Turkey Tom, okay, to see those drawings that I just showed you, the drawings. So he's pushing this narrative out there now when he could have pushed it out. Well, he did push it out many months ago. Now he's pushing it out more. Why? They wanted to put this note out. I don't think this is an accident. They wanted to push this note out to put it in the media. So we're in this rabbit hole. I'm not going in the Twiggs rabbit hole. I'm not doing the drawing rabbit hole. No.
Allie, one of the biggest points that Barron kind of said about the Turkey Tom, one thing that really stood out and probably would resonate with a lot of people, is that he said, why on earth would this person who had that much information, on Tyler Robinson, why would he go to Turkey Tom to turn over information like that? You know what I mean? Why not go to the police station?
That stuff in the beginning, I thought it was sloppy as F.
It was so sloppy, you wouldn't do it.
I'm not going to go down that hole right now. There's more important things for me to go down. I'd rather go down pastor rabbit holes than these drawings. And I just felt, and there's somebody on Spaces called Turkey Tom. I swear to you. If you go on X, you guys got to stay on X because it's these spaces that you'll hear these things. It is toxic. I'm not saying X is the greatest thing, but I showed Tornado Alley. You really hear a lot of things on those spaces. Okay. Yeah, Turkey Tom. Yeah, I know it's old, really old. It's on Substack. So Let's listen. He wants us to go there, though. He's like, I encourage you to go there.
There's a Turkey Tom YouTube video where one of their friends that would hang out with them in their apartment seems to indicate that it was a really manic, disassociative, sort of morally corrupt, bankrupt environment that Tyler.
His friend, Turkey Tom's supposedly a friend, and they put out these drawings. Apparently, Lance has these drawings, and it's all scripted, like it's the courtyard, and yeah, all that stuff.
Robinson was living in, and Lance Twigg seems to be the source for a lot of that. So did Tyler Robinson just do this crazy thing all on?
Did you see him? Did Tyler Robinson just? What the heck?
On his own, or did Lance Twiggs put him up to it? Was he a co-conspirator? I want to know that, because if it comes out that he was a...
You want to know that now. Now you want to know. Loser, move out. Get out. No. You don't care. Now you want to know? Where were you 9 months ago? You were on tour. You're doing the Charlie Kirk show. Now it's the Why Refi Studios. Why Refi? Why Refi Studios? That's what it is now. Owned by Waterstone in Colorado. Connected to Victor Marx. How all of a sudden a company, Why Refi Studios, now it's Why Refi Studios. They were just a sponsor. Now they're in this. They're called the studio. They're the studio. They're the studio. Sorry guys, I'm going off. I'm going off because they weren't there that long. They're a very new company, this Why Refi, and they're part of the Salem. And then we got Waterstone buying out Salem Media. Everything's connected here, guys. And I'm not liking the fact that he's talking about Turkey Tom right now. Like Twister. Loser, move out. Get out. I'm ranting.
Co-conspirator. I would love to see him held accountable for that and not be granted any immunity whatsoever. Another question I have is, where did Tyler Robinson go immediately after taking the shot, running off the rooftop, and tossing the gun into the forest? Where did he go? We know that the state has evidence that he was back on campus that night into the wee hours of September 11th, but where did he go immediately after? That's a big question. One of the questions that is really tough for me.
He has so many questions. It's so tough. It's so tough for him.
Is why were those darn rooftops so accessible? First of all, why set up a building where you can just
Why don't you ask yourself that freaking question? That was a weird pause. He looks like, oh my God, looks like something from the pits of down below. Okay. The rooftops. Why didn't you go inside? You guys knew. Why'd you say he's wearing a bulletproof vest and now he's not wearing a bulletproof vest? How do we know? Megyn Kelly said he was wearing one. Oh, and then what else did you're saying that you can't go on the rooftops? Then get inside. Take the shit inside. What you got open care? You got open. You changed the law got changed in August to having on campus to open carry loaded rifles and guns. So how the heck you gonna have shit outside? Who's responsible for this? Oh, I can't see anything on the roof. Who's responsible for the roof? Is it a roof? I can't see. Not one of those security guards had binoculars. Not one of them. I could see if somebody's on the roof. There's a witness that saw somebody on the roof. There's a witness that filmed somebody laying down on the roof, getting ready to take a shot. Nobody says anything? I'd be screaming. I'm like, fire, fire, man on the roof. I'd be like screaming my guts out. Who the heck's on a... If I saw someone on a roof, right away, I'd be like, danger, danger.
That's because it didn't happen. It happened, but it's not the story. You know what I mean? It's fake.
Yep. And that's everything is fake. He wants
because nobody goes, is that a guy on the roof? And we know what happened.
They're back. Sorry. apologize, everybody.
A record of what I noted that is at issue. And after I put this on the record, certainly if either side wishes to be heard about the court's understanding, I welcome your comments. Exhibit 24 was displayed on the monitor visible to the media camera. Exhibit 16 was displayed on all monitors and appeared on the live stream for approximately 3.5 seconds. The camera operator redirected the camera before any party called attention to the display of Exhibit 16. Approximately 16 seconds later, the court observed the image and stated, "Let me stop you, Mr. McBride. I'm not sure. Is this being broadcast?" Mr. McBride responded, "Let's take that down." The full text of Exhibit 16 had previously been made public through a search warrant that was publicly available on or before April 2026. The portion displayed on the monitors did not contain the full note and consisted of approximately 78 words. Approximately 15 of those words were included in the information filed on September 16th, 2026. In addition, the full note was read into the record during the preliminary hearing. The court previously ordered that Exhibit 16 be admitted into evidence and permitted its display within the courtroom, but prohibited its publication through the camera used for the live stream. And that concludes the findings of the court as it relates to this issue. Do the parties wish to be heard before we go into what you're requesting about the record on what occurred?
Your Honor, your recitation is accurate. My earlier comments were based on my memory of reviewing this last night. In the recess, I reviewed the feed again, and what you have said today is accurate.
Thank you. Mr. Novak, any?
No, Your Honor, I don't take issue with the court's factual summary.
All right. Turning to you, Mr. Novak.
Thank you, Your Honor. We're going to renew our request to exclude all electronic media coverage from all future proceedings. That was our motion docketed at number 305, and that included video cameras, still photography, and audio. This is the second time that the court's orders concerning the scope of electronic media coverage have been violated. I'm a baseball fan, and I just don't think the court needs to wait for the third strike. 2 strikes is enough. If I may, the alternative remedy, which we think is not wholly adequate, which is why we think it's an alternative and a less desirable alternative, is for this court to both reverse its prior order authorizing electronic media coverage of today's hearing, which we had previously filed an objection to after the court, I would say preliminarily granted the requests for today. That was sort of the chain of events. And that the court proactively preclude electronic media coverage at the last day of the preliminary hearing, which will be September 1st. Now, I understand that there has not yet been a request for electronic media coverage for September 1st, but there is no doubt that there will be, just as this court previously observed that it wasn't prepared to preclude electronic media coverage at the preliminary hearing because there had not been any requests. There were requests, and those that were timely were all granted. The court denied one request because it was not timely for one particular day. So I guess the way it would be is any request for electronic media coverage of September 1st will be denied because that's the appropriate sanction for what happened yesterday. The fact that the content of the exhibit was previously summarized by the state in certain documents which became public because the state didn't take any actions to seal them beyond the 6-month period. The fact that the contents of the exhibit were read in open court is not the issue. The issue is when the court issues an order, everybody must comply with it, and there are reasons for the order. And the reasons, as this court stated, are to protect Mr. Robinson's right to a fair trial. So no doubt that the court balanced those prior ways in which the content of this exhibit had already been disclosed when the court decided that there would not be electronic media coverage. That's the fact that we have all known of that exhibit. That's a fact that we've all been aware of as we've gone along. So to summarize, and then I will stop because I know we still have a witness here, and of course the court needs to hear from the state and counsel for the media, I suspect, is we would like the court to reconsider its order denying motion 305 and grant it for the balance of all of the proceedings in this matter. Or as an alternative, the court prohibit any further electronic media coverage of the preliminary hearing, which includes September 1st.
Thank you, Mr. Novak.
Thank you very much.
Turning to the state and then to the media.
Yes, Your Honor. As to the remedy, we've heard of instances where the media has been able to delay publication of the recordings of the proceedings. We've heard of instances where that has been a short delay of like 30 seconds. I've talked to the media attorney about this, and they do not have the capability to do that right now. My suggestion would be for future proceedings to order the media to look into that capability, and that would be a remedy that perhaps could be used in the future. I think that would be a satisfactory remedy to avoid this type of thing in the future. As to the other remedies requested, we have one witness. The final witness, well, the defense has one witness. That witness is a ATF DNA forensic biologist. And I assume that the exhibits that will be admitted through her will be of that nature. We've already, in fact, admitted the report that she is going to be testifying to. The reports, I should say, that's exhibits 30 and I believe 34. And so I don't think we have, and those have already been published. I don't think we have the same risks or, I'll just say risks with her testimony as we do with some of this other evidence that has already been admitted.
Thank you. To the media.
In a proceeding like this, the parties in the court and the media are working together to learn and to refine their processes. I hear Mr. Novak's remarks about challenges that we've run into in the past. I recall, it hasn't been that long ago, a time when the camera was placed in a location in the courtroom that was causing challenges. The court moved it. When there were challenges with aspects of the court's ruling, the court reiterated those, and those processes improved. We are getting better at this. Media is on board and recognizes the court's obligation and its significant efforts to balance the interests here. In light of the court's ruling, including its recognition that the media operator in this case beat almost all of us to the punch, right? And saw what was happening on the screen and moved away as quickly as they could. We believe that the procedures that the court currently has in place, even if they don't every moment of every hearing deliver the result that we are intending to deliver, those processes are working. I don't believe that a further adjustment, much less a sanction, much less a revisitation of something that says let's keep every photographer, every camera out of this courtroom for every proceeding. In light of the court's well-reasoned and exhaustive rulings after long briefing on all of this, the court is currently balancing these interests correctly, and we therefore ask the court to allow the parties to recognize that the time we're dedicating this morning represents a reiteration of the importance of these principles. The media and the parties all recognize that. We'll continue to endeavor at all times to do all that we can to ensure that those are adhered to, and let the parties go forward under the current procedures without further order or sanction by the court.
Thank you. Any further arguments before the court issues its ruling?
No, but thank you for the opportunity.
Thank you. and just updating my notes as I'm intending to issue this ruling right now. I'm just making sure that I am capturing all the points made in the argument right now.
Well, that took a chunk out of the whole entire morning, didn't it? Didn't it? I don't like this. I don't like it. So we're not allowed to see anything anymore? Is that what's going to happen? Is that what's happening now? Oh man. I'm not.
That or they're going to delay the media by,
Yeah.
some kind of seconds.
I don't know why I'm so nervous and my stomach is upset and I'm just trying to put some updates here. Okay.
What do you think he's going to do?
I don't know what he's doing. He's typing fast though. He's typing fast. Okay.
I wouldn't want to be the person to have to make this decision.
No. Okay, so let me play this so we keep everybody updated because people are sometimes just popping in. They don't know what's happening. Novak says there are reason for court orders and everyone has to follow them. Prosecutor McBride proposes a delay in the live feed for future hearings. McBride says there is one final witness today. And her exhibits have already been admitted. Media attorney says media and parties are working together. Thank you, baby. To try to resolve issues when they come up. Media is on board and recognizes the court's obligation and significant efforts to balance interests here, and the camera operator beat all of us to the punch. Did I do another one? Or is that the last one? I think that's the last. Yeah, that's the last one. I'm gonna see. There you go. That was the last one. Whew. And I'll put the live updates here too. If you guys don't have it. This is the live updates. You guys can all check it. Keep refreshing the page and you will see all the notes there.
All right.
I know who you are, but what am I?
Almost done. I appreciate the party's patience. this issue rises to the level that necessitates great care. And as my practice, I don't like to rush or make snap decisions. And I want to give this the full analysis that it's due. So thank you again for your patience.
I just want to put it out there. He's never done a homicide case before. Okay? And he was appointed to be the judge in Utah in May. Hello. Hi. Yep. I did a whole thing on him.
Right. Court will issue its ruling on the request by defense.
He did
The constitutional rights of Mr.
cases.
Robinson and Ms. Kirk are paramount. Although transparency in judicial proceedings is a fundamental interest, it must be balanced against the constitutional rights of all parties. Having considered the arguments presented by counsel and having reviewed the events that occurred yesterday, the court finds that its order prohibiting the publication or broadcast of Exhibit 16 by the media camera was violated. The court agrees with the defense. This constituted a violation of the court's order. Compliance with court orders is essential in all proceedings and is of particular importance given the nature of these proceedings. With respect to defense's request as a sanction that the court reverse its ruling on defense motion 305, motion to exclude cameras, the request is respectfully denied. The analysis underlying the court's prior ruling remains unchanged, and the court adheres to its reasoning and conclusions. With respects to the defense's alternative request as a sanction to prohibit all cameras and electronic equipment from today's proceedings, thereby preventing the electronic capture of the proceedings for those inside and outside of the courtroom, the request is granted in part and denied in part. Effective immediately, members of the media shall no longer capture or broadcast any exhibits displayed by the parties during today's proceedings. The court finds this sanction to be proportional and appropriate in light of the violation of the court's prior order. The court reserves this sanction as it relates to September 1st. It is not before the court. There has not been a request for electronic media coverage, and the court won't issue a pre-ruling. When it becomes, that request has been filed and all the deadlines which the court has imposed in regards to the MC filing are in place, if motions are filed, the court will entertain motions in brief argument ahead of the September 1st hearing and address it at that time. This is the ruling of the court. Thank you. Turning to the defense, if you wish, you may call your next witness.
We would like the benefit of the record before we start taking evidence today.
Yes, Mr. Grenander, and I'll allow all parties, given the ruling of the court, briefly.
And I'll be brief, Judge. And this is in relation to the continued taking of evidence today. And I'll start my statement, Judge, with something that was very insightful that you said the other day. You mentioned, and I quote, "Sometimes you need to take time to save time," close quote. And so that's my purpose for standing up here this morning. We have spent the better part of a day, a little over 5 hours, I believe, hearing from witnesses that the defense has called at this preliminary hearing. And no doubt the defense is entitled to call witnesses at a preliminary hearing as allowed by the rules. But I think it's important that the court remind all parties about the purpose of this hearing. This is a probable cause hearing, as Your Honor has repeatedly stated. The defense has invoked the term reliability many times. And the court, frankly, has found the evidence that's been admitted, the testimony. As a gatekeeper, the court has found it reliable. It's been presented. The exhibits have been found reliable. So any questions of additional reliability are really questions of credibility of the witness and weighing of the evidence. And that is not really what this court engages in at the probable cause standard. And so
This is all couched in the context of a likely forthcoming standing objection that the state may lodge if the testimony is long and drawn out and exceeds the scope of the preliminary hearing, gets into areas of a 702 hearing, possibly even trial. We will lodge this objection, but I wanted to just simply state the authority, Judge, behind our objection if we do make that. As your court is well aware, the magistrate at this stage of the case must view the evidence in the light most favorable to the prosecution. And that's cited to in a number of Utah cases, to include State v. Schmidt. Schmidt continues, this means that when reasonable inferences from the evidence cut both for and against the state's case, the magistrate lacks the discretion to choose between them and must leave such a determination to the fact finder at trial. A few other cases I would like to refer the court to. State v. Pledger, which is a Utah 1995 Supreme Court case. Speaking of this standard, the court says, the standard bars the magistrate from requiring the prosecution to address or even eliminate alternative inferences that could be drawn from the evidence in favor of the defense. So even assuming the defense scores points today in calling these witnesses, again, the court cannot really weigh those in favor of the defense. State v. Hester, which is a Utah Court of Appeals case 2000, where there is conflicting evidence, quote, the magistrate may not sift or weigh the evidence, but must leave those tasks to the fact finder at trial. Of course, we're not at trial yet. State v. Virgin, a Utah 2006 Supreme Court case, indicates that a magistrate may only disregard evidence at a preliminary hearing if it is, quote, so contradictory, inconsistent, or unbelievable that it is unreasonable to base belief of an element of the prosecution's claim on that evidence. There's a State v. Drozbecki case, which is a Utah Court of Appeals case 2010. Magistrates may only disregard or discredit evidence that is wholly lacking and incapable of creating a reasonable inference regarding a portion of the prosecution's claim, but must leave all the weighing of credible but conflicting evidence to the trier of fact. And finally, State v. Lopez, a Utah 2020 Supreme Court case. Speaking of this probable cause standard at a preliminary hearing, the court said, under this low bar, it may be difficult for the defense to overcome a prima facie showing of probable cause. Even an alleged victim's recantations may sometimes be insufficient, given that the magistrate must view all evidence in the light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution, close quote. Judge, Your Honor has heard 4 days of testimony now. The evidence is overwhelming. It's devastating. And the question needs to be asked, the purpose of continuing with testimony if it's long and drawn out. Of course, the defense has the right to call witnesses, but it needs to be within the context of this preliminary hearing. So again, we may be lodging a standing objection of relevance and exceeding the scope of this hearing. That's my record.
Thank you, Mr. Grunander. Do other of the parties wish to be heard as it relates to Mr. Grunander's statement? To the defense?
I'm not sure what was being requested by Mr. Grunlander. As I indicated to the court during the testimony of the last witness, we had discussion with the state prior to the start. We had a scheduled date for the court to rule on objections. And the purpose of that hearing was so that we wouldn't have to fly witnesses out from the East Coast if there was going to be a standing objection. Prior to that hearing taking place, the state contacted us after they had participated in interviews of Ms. Oliver and the other experts, and indicated to us, and we indicated to the court, that there was going to be no standing objection to the testimony of these witnesses. So if he's lodging a standing objection now, I think he's waived it, or he should be stopped from asserting it given the circumstances. I didn't hear that he was asserting that, and I intend to keep this next witness focused on the issue that I think is relevant, which is the state presented DNA reports through a non-expert. They selectively read into the record a portion of those reports, which left an extremely misleading impression of the significance of that evidence. So I have the author of the report here, and I'm going to hopefully educate the court on what the limitations are of the report, and that's it. I hope to be done with the witness by noon, direct and cross, and that will be the end of it.
All right, thank you, Mr. Burt. And before I have you call the witness, just want to make sure that the media had well, I'm not sure if the media needs to be heard on Mr. Grunander's response. All right, thank you. All right, Mr. Burt, you may call your next witness.
Thank you. Call Miss Oliver.
Ms. Oliver, if you'd like to come forward and be sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, ma'am, you may be seated. And there's a water bottle to your left if you wish. And after you're seated, if you wouldn't mind adjusting
Don't
that
drink
microphone,
that.
bringing it close to you to pick up your testimony from today. Mr. Burt, your witness.
Thank you. Could you tell us your name, please?
Caitlin Oliver, Oliver.
And Miss Oliver, could you bring that mic a little bit closer? So I want to make sure your voice is projected. Thank you. What do you do for a living?
I work for the Bureau of Alcohol, Tobacco, Firearms, and Explosives as a DNA section chief.
And how long have you held that position?
I've been a section chief since January, and I've worked with the ATF for about 9 years. Prior to that, I was a forensic biologist.
And where were you a forensic biologist before you started to work for the ATF?
Prior to the ATF, I worked for Jefferson Parish Sheriff's Office in New Orleans, Louisiana, as a DNA analyst and a DNA quality manager.
Back in September of 2025, what were your duties and responsibilities?
I was a forensic biologist.
And do you recall that around September 11th, you received a request to do some DNA work at the request of the state of Utah?
Yes.
Could we display State's Exhibit 30, which is in evidence?
And she is Caitlin Oliver. She's specialized in forensics, right? I'm still waiting for the proper. And hey, done with fence slop. I am ATF. Ellie Top Files. Me, I am. Not them. No, I'm just joking. Anyway. I forgot who called me ATF. I can't remember. But yes, so another ATF lady. Yeah. I'm just putting updates here, guys. Buckle up. This should be good. If we can hear anything or see anything. I'm just putting updates here, guys. And then yes, that's what it was. Forensic biologist background. Oh. Forensic biologist background. Here comes the mind control. And they're drinking from the water they provided. You can't go in there with water. You have to accept the water that they're giving you. I wouldn't drink it. I would not drink any of that water. I would just, chug the stuff before I went in there. You have to bring it in an empty water bottle. We had Brandy and Teresa on our show yesterday, and they said you can't even bring water in there. You got to bring empty water bottle and then fill it up with their water. That's bizarre. What do they think you're going to bring in there? Different type of fluid? I don't like. I don't get it.
Well, I guess we have a lot more chatting time because we're not going to be able to hear this stuff.
Yeah,
or see it.
No.
Which
the judge looks annoyed. He looks seriously. The judge has different water, does he?
He's got like Pierre.
Special water.
He's got sparkling water.
Liquid explosive. I would not drink it. What are you guys saying? Whoa, what is happening here? No, I would hold everything in my you can't even go to the bathroom there. You have to, like, if you leave, you can't come back. So thank you, baby. Whoa. Thank you.
Oh,
What?
Is Chris coming?
He is. He's just on a
Yay.
phone call. Yeah, he is. He's
Yay.
he will be here with us today, the whole day.
Oh, here we go.
Okay.
Where the state read paragraph D, admitted paragraph.
Allie? Where did you go? She probably just booted herself off or something. She'll probably be right back.
I really apologize for this.
We forgive you.
He handed me something and then something happened.
It's okay.
Give me one.
It's all Chris's fault.
Portion discussing evidence is that you understand that that's going to be captured by
Can you
the
hear it?
camera and displayed, but not any exhibits.
Can everybody hear it?
displayed. Is that your understanding?
That is my understanding of the court's ruling, yes.
And to the state?
Yes.
And to the media?
Yes, Your Honor. There might be concern about the actual monitors, the counsel table, and podium. Any clarification on that?
Well, that's why I give my notation to begin the morning that the parties are responsible to monitor their monitors. And that's there because they're entitled to view it, but they're responsible to ensure that the monitors, as the camera is picking up the courtroom, it's directed not to focus on the monitors, but inevitable capture may occur, and that's why that instruction is given.
Your Honor, Jeff Nine on behalf of the victim representative. We cannot see the court from where we are sitting, so I don't know if there's a way for us to view the monitor.
I don't understand what you're saying.
It's not being published on this
It's not
one.
being published on the monitor to the court's right.
Right, the order of the court based as a sanction is no exhibits will be displayed.
In the courtroom entirety?
As it stands right now, yes, that's correct. Okay, please approach the lectern.
Your Honor, it's just hard for the victim's family to be able to follow the evidence if everyone but the victim's family is able to view the exhibits here in court.
Thank you, I appreciate your concern. This monitor is not on either. So it's only the attorneys. The attorneys have a right to view what exhibits are being displayed, to make their motions, objections, and to see it. It is the court's discretion on what's displayed in the courtroom for publication, and the court issued a sanction given the events of yesterday, and that's the court's ruling.
Your Honor, I just asked the court to consider the victim has the right to be present, obviously, at the hearing. And the presence without being able to see the exhibits, again, it's our position, is not meaningful.
Thank you. I appreciate your concerns. Mr. Burke.
Could you redisplay exhibit 30, please? And again, while he's doing that, that same conclusion where you include the language, go back to that page, please, 5. Use the term, there is evidentiary support and possible contributor. I want to focus your attention on the words evidentiary support. We've had a prior witness testify that from the FBI testified that they use a scale and they characterize the support along the lines of strong, Yeah, are you familiar with that type of a scale?
Yes,
Does your agency employ that scale?
we can come to 5 conclusions at our agency. So there can either be exclusion, limited support for exclusion, uninformative, limited support for inclusion, and support for inclusion.
And I take it from what you just said, you don't use these qualifiers strongly. The word strongly include things of that nature.
Yes, we don't use a verbal scale at our laboratory.
Is that a scientific phrase when you talk about instead of saying that there's support for an inclusion, you instead say there is strong support for the conclusion?
So our laboratory doesn't use a verbal scale due to the fact that they add subjective words to the front of this word support. It is our stance that the likelihood ratio statistic, the number stands on its own. So we report the likelihood ratio and either support for inclusion or support for exclusion.
Thank you. Would you go to page 8 of the report and highlight the very top of the first 2 sentences? You included this language in your report, correct?
Correct.
And in fact, you included this language in all 3 of your reports, referring to the conclusions conform with the relevant Department of Justice policy on uniform language.
That's correct.
Right. And why do you include that language in all 3 of your reports?
It's standard language for our reports. Our reports adhere to the DOJ Ultra statement.
Okay. And could you go now to Exhibit Oliver 4 for the witness only? Not admitted yet. Are you familiar with this document, the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examination using probabilistic genotyping systems?
Yes, I am.
Right. And would you go to page 4 of that document, please? And the court has heard some prior testimony about this Department of Justice directive. What is ATF's, what is your understanding of what the qualifications and limitations are that are required by this policy of the Department of Justice? What are you not supposed to be saying in connection with the reports that you wrote in this case?
There's a few things that the Ultra document states. First, it states if you use a verbal scale, which we do not, then you need to use the one dictated in the document. This is in an effort to unify the language coming out of DOJ laboratories. It also says that we cannot state that our evidence is infallible, nor can we state that there is a inconclusive result.
Shall not state that it's infallible or have a 0 error rate, correct?
Correct.
It also states, does it not, that you shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample.
Correct.
And are your reports in conformity with that? You're not stating or implying that anything you did here is asserting an absolute identification of someone as the source of any of the evidence that you examine, correct?
Correct. With forensic evidence, it's impossible to state with 100% certainty anything. That's why we report a likelihood ratio to speak to that uncertainty with a statistic.
All right. And would you go to the next page of that document? This policy requires that you not state or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty. You didn't do that in any of your reports, correct?
Correct.
You're not asserting anything with respect to any reasonable degree of scientific certainty.
Correct.
Correct. Now, when you can take that down, when did you first receive the assignment in this case?
I would have to refer to my case record to know the exact date.
Do you have those in front of you?
I do not.
Okay. let me pull up Oliver 3 for the witness only. And go to the third page. Does that third page help refresh your memory on when you may have received this case?
Yes, on September 12th, 2025.
Okay. Is that when you first started doing work on the case, do you think?
Yes, it is.
Now, prior to doing work on the case, did you receive permission from someone to consume any samples in the case?
Yes, I did.
And could you go to page 15 of those case notes, please? Again, for the witness only. Do you recognize this email?
Yes, I do.
And can you tell me what the email is and what information it conveyed to you in connection with your examination?
Yeah, so it's standard procedure at our laboratory that when we receive a case, we request permission to consume from the agent. We request that they reach out to an attorney if one is assigned. In this case, we will not begin any work on the case until we've received that permission to consume. So this email is us receiving permission to consume the samples and move forward with testing.
Now, does your policy have, does your lab have a policy for preserving samples for independent testing by the defense?
Where possible, we will not consume samples where it's possible.
And that policy is a longstanding one, not only in your lab, but pretty much everywhere in forensic DNA analysis, right?
That's correct.
Goes back to 1996, does it not, when the National NRC recommended a policy that samples be split wherever possible at the front end of the analysis to allow for independent examination.
Where possible, yes, that's correct.
Right, and they did that because it was their conclusion, was it not, that a wrongfully accused person's best insurance against the possibility of being falsely incriminated is the opportunity to have the testing repeated. Such an opportunity should be provided whenever feasible.
Correct.
Okay, could you now go back to Exhibit 30? Page 8. Were certain DNA samples consumed in your analysis?
Yes, they were.
And for the record, are those listed on page 8 of your report?
Yes, they are.
Which samples were entirely consumed in your analysis?
That would be exhibits 1.4, 1.6, 1.9, 1.10, 1.12, 2.1, 3.1, 4.1, and 5.1.
Okay, then are there a number of samples listed above there in the report where you say the DNA extracts will be retained? And then you list 1.1, 1.2, 1.3, 1.5, 1.7, 1.8, 1.13, 7.1, and 8.1.
Correct.
Does that mean that those are all swab samples, correct?
They were swabs, yes.
All right. Does that mean, does your report mean that you consume the swabs, but you have some liquid extract remaining as to those samples?
Correct.
Now, are all of the samples, let's talk about the samples in Plaintiff's Exhibit 30. Were all of the samples you looked at there mixed samples?
I refer to my tables in my report.
Sure. Go to page 2, please.
And can we go to page 3 and 4?
3 and 4, please.
with the exception of the known samples from the known individual, that was a single source sample, but otherwise the evidence samples were all mixtures.
And in many cases, they were mixtures of sometimes 4 and 5 people, correct?
Correct.
Now, when you look at mixtures such as the ones in this case, you use terms like major and minor contributor, right?
Correct.
Is that language meant to convey that anything with respect to activity of anybody who might be assigned to that DNA weight? In other words, are you saying the person you label as a major contributor was engaged in any sort of activity? Is there any connection between the use of that language and activity?
None of the testing that I performed could speak to activity or what activity led to the deposition of the DNA.
So nothing in your report, if somebody reads that and says, oh, this one says this person is a major contributor, you're not commenting on anything about the person's activity, correct?
Correct.
And is it true also that there are also several other limitations concerning the language of your report that it's important for courts and people who are reading the report to understand?
I'm sorry, what was the question?
Are there other limitations in addition to the one we just reviewed that it's important to understand about the language you use in your report?
In terms, is there something specific that you're?
Yeah, there is. Could you go to Baker Exhibit 30, page 1, for the witness only? Are you familiar with this publication?
Yes.
This is a publication by the National Institute of Standards and Technology called Forensic DNA Interpretation and Human Factors.
Correct.
This is put together as a guidance document for practitioners on what to simplify, essentially what to say and what not to say.
I don't know that I would call it a guidance document. NIST is not a regulatory body for DNA testing. It was a report that looked into forensic DNA reporting and specific human factors that could affect our testing. So they may have had recommendations, but as far as them being a regulatory body that's issuing guidelines, I wouldn't state that.
Okay, that's fine. Could you go to 136, please? (136). This is Baker 30. Keep going. There we go, right there. Wait, 135, I'm sorry. And then scroll down to the next page. So they're making recommendations here as to how the report should be worded, correct?
Correct.
Let me ask you whether you agree with some of these limitations, or they call them caveats. They talk about how you describe the number of contributors, and they say the true number of contributors of DNA to an item can never be known. Do you agree with that?
Yes.
Okay. They also say, let me ask one question before I ask this one, which is, do you use something called a reporting cap in all three of your reports?
Yes, so for our likelihood ratio statistics, we cap the statistic at 1 trillion. The actual number could be a lot higher. It could be quintillion, octillion. We chose 1 trillion because it has meaning, I think, to people that can understand what 1 trillion is. An octillion and a quintillion gets a little high at that point, so we cap at 1 trillion.
And they talk here, do they not, about how you convey the idea of a reporting cap? And they say the LR reporting cap was chosen because of the limitation of biostatistical modeling and independence assumptions of STR loci. Do you agree that that's why the cap is chosen?
I believe we chose our cap for the reason I stated.
Do you disagree with that statement in terms of why the cap is chosen?
I'm not familiar with the paper that's referenced there, so I would have to familiarize myself before I said I
Okay.
agreed or disagreed.
Fair enough. And then they also suggest that you alert in your report that profile descriptors cannot be applied to activity level issues. Do you agree with that?
Yes, so this is what you were stating about calling a major contributor. It doesn't speak to the activity that led to the DNA deposition.
Right. DNA profiles may be described as major, minor. However, these descriptors should not be interpreted in the context of a decision regarding the nature or the mechanisms, actions, or timing that led to the deposition of the DNA. You agree with that?
Correct, yes.
All right. And then the other sort of limitation, convey that the DNA results cannot be interpreted as the analyst providing an opinion regarding who the source of the DNA is.
Yes, so this is once again, we don't make source attribution statements. We will say there's support for inclusion, and then we back up that with a statistic.
So from a scientific standpoint, you couldn't read the paragraph that sets out the likelihood ratio in your report, whatever the number, and then blast a headline in the media, Mr. Robinson's DNA is found on this item. That's a source attribution, is it not?
Correct, yes.
And that would not be scientifically defensible, would it?
Correct.
Okay. Another limitation they talk about on likelihood ratios on the next page, please, 137. Likelihood ratios cannot speak to the likelihood of a proposition, only to the probability of the results given a pair of propositions. Do you agree with that?
Yes.
Explain that, because that's a little above my pay grade in terms of understanding.
So a likelihood ratio statistic compares the probability of the DNA profile of the evidence given two competing hypotheses or two competing scenarios. Typically, the first is that the person of interest is included, and then the exclusionary hypothesis would be that the person of interest is excluded. So there's a random, unknown, unrelated individual contributing.
And when they're elaborating on that point, they say a likelihood ratio indicates if and to what extent the DNA analysis results support one proposition over another. It is not possible on this basis alone to determine which is the most probable proposition. Do you agree with that?
Yes.
Okay. And then the next limitation they suggest you convey is that convey that DNA statistics cannot imply uniqueness within a population. Do you agree that that's a legitimate limitation?
Yes.
And explain what that means. Does that go back to the issue of source? You can't assign a source to a DNA sample?
Correct.
Okay. It says you should delineate the meaning of a verbal qualifier, but you didn't use one in this case, right?
Correct.
Okay. Now, you mentioned that your testing cannot, and correct me if I'm wrong, I don't mischaracterize it. Your testing, none of the testing in any of the three reports can answer the question of how and when DNA got deposited. Is that true?
That is true. DNA can't speak to the activity that led to the deposition of the DNA.
And the report says, with regard to that issue, with the increased sensitivity of DNA techniques and sophisticated software, a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swabbed. Alternatively, a person's DNA may be present when they were not involved in the crime. Do you agree with that?
Yes, once again, I cannot speak to the activity.
Can you explain how it's possible that a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swabbed?
So it's possible if, say, the pen that you're sitting there using for the week, you say hand it off to the judge, and the judge then touches it for a period of time, and then I swab it. It doesn't speak to who handled it last. I could test that. I could get both of your profiles. I wouldn't know which person was the last person to handle that item.
All right. And similarly, if you had a lot of DNA on your hand, we shook hands. I then went to pick up an exhibit, a gun. I touched the trigger of it. Your DNA could be on that trigger, right?
It is possible, yes.
Okay, even though you never touched the gun.
Yes.
And that's why, because of those possibilities, you can't make any assessment of how or when DNA got deposited, correct?
Correct.
How long can DNA persist on an item?
DNA is quite stable over time. It can be broken down due to environmental insults. So things like heat and humidity are known to break down DNA over time. But I couldn't give you an exact number.
Were certain of the samples that you tested in this case degraded samples?
There was degradation present in some of the samples.
And what can cause degradation?
Like I said, there's environmental insults, heat, humidity.
Now, the second report that you wrote had to do with a Dremel item that was taken from Mr. Robinson's home.
Correct.
And did you request certain what are called elimination samples in regard to items that were recovered from his home?
Yes.
Tell the court what an elimination sample is as opposed to a sample that relates to what's called a POI, person of interest.
So an elimination sample is a sample taken from a known individual that it may be assumed that they could have come into contact with it. If I were to say swab your vehicle, then I would want your DNA sample as an elimination to eliminate you in order to look for any additional DNA that may be there.
And you say they're assumed contributors because depending upon the location, for instance, somebody's house, you would expect if there were multiple people in that house that perhaps everybody in the house could contribute to a certain DNA result.
It's possible.
So you'd want samples from all those folks to see if they contributed to an item that would be associated with a place where they congregated.
Correct.
And I noticed from your case file that you also requested, but I don't think you received, elimination samples from agents who were involved in this case.
Correct.
Why do you request those samples?
The type of testing we perform is quite sensitive. And so it is a standard practice that we request elimination samples from any of the investigators involved in order to potentially eliminate them in case they could have contaminated the evidence.
Okay. Now, in report number 157, if you could bring that up, please. Oliver 157, which has been admitted. The elimination samples that you requested in connection with items seized from Mr. Robinson's apartment were from Amber Robinson, Matthew Robinson, and Lance Twigs, correct?
Correct.
And that's because you had information that those people were associated with the house.
Correct.
And when you tested or compared, first of all, you determined their DNA types, right?
Correct.
Then you compared their types to what you found on the evidence.
Correct.
And for a certain number of those samples, you found the presence of DNA of your elimination samples, not because they were suspects, but because they were associated with the premises, right?
There was support for inclusion of some of these individuals, yes.
Okay, and if you could scroll down to page 4, which is the table. I just want to review briefly with you. For instance, item number 1.4, which was a swab from the rifle. You used the elimination sample of Mr. Robinson's father, and you found his DNA on that particular swab, correct?
I would say there was support for inclusion of Matthew Robinson on the sample obtained from the swabs of the bolt of the rifle.
I'm glad you pointed that out. That's, again, consistent with your other testimony. You're talking again about support for inclusion as a possible contributor.
Correct. And
Again,
there
not because he's a suspect, but because he's associated with that premise.
correct. And there would have been a likelihood ratio statistic calculated and to go along with that.
Okay, could you go to the next page? Similarly, with respect to 1.6, you found, again, Matthew Robinson on swab number 1.6, or a profile that indicated he was a possible contributor.
There's support for inclusion of Matthew Robinson.
Okay. And next page, actually go 2 page to page 7. You found support for inclusion of Lance Twigs on swabs of buttons of a Dremel tool, correct?
Correct.
And going back to what we were talking about before, if a person named Lance Twigs lived in that residence, came into contact with Tyler Robinson, and then touched a button on a Dremel tool, you'd expect Mr. Robinson and Mr. Twigs's DNA to be on there, right? Or you could.
It's reasonable to assume that anyone living in the household could have contributed to DNA on an object found in that household.
And similarly, you found profiles to suggest support for inclusion of Mr. Twigs on other areas of the Dremel tool, correct?
Correct.
Okay. Now, the last area I want to ask you about is, you're familiar with something called NGS?
Yes.
What is NGS?
NGS stands for next generation sequencing. It's a DNA technique that sequences your DNA. So it looks at the individual sequence of your DNA.
And is it true that in your field, that whole area of NGS is something that's at the forefront of everybody's attention? For instance, when you go to seminars and you look at the presentations, there's a lot of talk about NGS, right?
That's correct. Yes, it's a newer technique.
And is it being developed by ATF as a technique that's going to be used or has been used?
Not at this time, no.
And is there plans to do that?
Not at this time, no.
Okay. Do you know if other labs have implemented it?
I believe there may be some laboratories in the United States that have it in use, but I wouldn't have direct knowledge of that.
Now, you used a program in this case called STR Mix, correct?
Correct.
And that's sold by a company in New Zealand, that software?
Correct.
Have they developed another program called STR Mix NGS?
I'm not aware of NGS software.
Could you go to 156 Oliver 156. Let me know when you're there. Are you aware that STR, the developers are selling a product called STR Mix NGS?
I was not aware, no.
Okay. Now, sequencing analysis is different than what you did in this case, correct?
Correct.
And how so?
As I said, sequencing is looking at the individual sequence, the individual bases that make up your DNA, as opposed to the testing that I'm performing, which is looking at length variations. So STR testing, which is the testing I perform, looks at areas of the DNA that are known to be highly variable between individuals. And there are areas where the DNA sequence repeats itself over and over again. And depending on who you are as an individual, you may have a different number of repeats present at that location. So the testing we're performing is looking at those length variations. There's a distinction between, say, if you have 10 repeats versus 12 repeats.
But you're not looking within those lengths to see what the sequence of the DNA is.
Correct.
And that's what this new technology is designed to look at.
Correct.
And the reason it's designed to look at that is because it's been found that there are DNA areas that are different in sequence, even though they're the same length. Is that true?
I think the reason for developing NGS software is to add another tool to a forensic biologist tool belt.
Okay. Now, could you go to 154, please, for the witness only? You're familiar with this chart?
Yes.
Okay, this lists all the alleles that you found for all the testing in your 3 analysis, correct?
No, it looks like
No, you were right, 154. Yeah, this is one. What's the exhibit on this? Okay. You're familiar with this chart, right?
I reviewed the first page of this chart. I have
Sure.
not reviewed the entire
Go to the
thing.
first page. This lists the alleles that you found, correct?
For the known samples, yes.
Okay, now go to the second page. And is it true that for the alleles of interest in this case, one of the alleles of interest is at the D3 location, allele 17?
One of the locations that we look at on the DNA strand is called D3. That's a location, yes.
Right, and in this case, the 17 allele is important because Mr. Robinson had a 17 allele, correct?
Correct.
And some of the evidence had a 17 allele.
Correct.
At that location.
Correct.
So as I understand the way you do this, you look and compare whether those are the same number, basically.
I wouldn't state that's how we do our comparison. So it's not just number matching. We're using STR Mix, the STAR Mix software, in order to perform an analysis of the software that looks at the possibilities for a DNA profile and make comparison to the knowns that way. We aren't using a chart and just doing number matching.
Yeah, and I wasn't suggesting you did, but you're looking at the alleles and measuring the peaks, and it's a fairly sophisticated process, correct?
Correct.
But the bottom line is you're comparing alleles one against another.
Correct.
So if a person is a 1717 and the evidence sample is a 1717, you're looking at that comparison.
Correct.
And again, measuring only length.
Correct.
But it's true, is it not, that researchers have found that that particular allele, the D317 allele, that there are actually 3 different 17s, 17A, 17B, 17C.
Yeah, so there's something known as isoalleles. What that is you may have, in this case, a 17 allele But the sequence within that 17 allele is different. So two people may have a 17, but they may have a different sequence within their 17 allele.
And it's been found that there is a 17A, a 17B, and a 17C, correct?
Objection. Relevance to the probable cause hearing. At this point, I think we've once again gone beyond probable cause, and based on Mr. Grunlander's argument, I would invoke his argument here in the case law that he referenced, and I object to this question.
Let me withdraw the question, reframe it, and move beyond it.
All right, so I'll sustain the objection. It will be reframed and we'll go from there.
It's true, is it not, that at least 1, 2, 3, 5 of the locations of interest in this case, researchers have found that the alleles that you were looking at, these isoalleles, have different sequences but the same length.
Objection. Relevance. The witness has testified she does not do sequencing analysis here, and that's what the question is asking, is about sequencing analysis.
Counsel?
The point, though, is that her testing cannot distinguish between these isoalleles, and therefore it goes to the weight of the comparisons.
But if she didn't do that,
Yeah, that's the point, is that she didn't do it, and therefore she's not in a position to draw conclusions.
Mr. McBride?
That proffer is inaccurate, that she's not able to draw conclusions because she did not do NGS or sequencing analysis. She has testified that her lab and the analysis she did here is not sequencing analysis, it's something different. Whether or not she could do sequencing analysis is irrelevant to the analysis that she did do. If Mr. Burt wants to call an expert to say sequencing analysis is better or something like that, that's fine. But this expert does not do sequencing analysis. Therefore, the line of questioning that goes into sequencing analysis is irrelevant to her testimony.
Let me see if I could lay a further foundation.
All right, so I'm going to sustain the objection. And the question may be re-asked if counsel chooses.
When you do your analysis using length only, do you go by the rule that if any STR locus fails to match when comparing the genotypes between two or more samples, then the comparison of profiles between the question and reference sample is usually declared a non-match, regardless of how many other loci match?
No, it's not quite that simple. What you're speaking of is an exclusion, is that correct?
Yeah, right.
So it's possible for DNA evidence we spoke about, it's possible that DNA evidence be degraded. In a case like that, there may be the potential that some of the profile has what we call dropped out. So it's not present. In that case, we wouldn't expect necessarily to have a inclusion or exclusion at that location because there's no information present there. So it's not quite as simple as is every allele in this chart present in the evidence. There's more to it than that.
If you had a difference in sequence between a known and a question across many loci, would you exclude the person?
It depends.
Again, objection, Your Honor. We're going back into sequencing, which is not the analysis that was done in this case.
Mr. Burt?
Again, Your Honor, if there could be an exclusion based on this and the testing was not done, I think that is relevant.
But as it relates to this witness and her firsthand knowledge, I'm not seeing that tie-in as it relates to her.
All right, let me move on then.
So I'll sustain the objection.
Now, you said that all the samples you looked at in that one report were mixtures, correct?
Correct.
And the number you get in the likelihood ratio depends on how many contributors you estimate, right? The number is going to vary if you say I think it's a mixture of 2 people versus I think it's a mixture of 5 people.
It's not necessarily the number of contributors. The likelihood ratio speaks to the weight of the evidence. And so it's comparing known individuals to the unknown sample. It could be a low number and be a single source sample. It could be a high number and be a 4-person mixture. It's not necessarily directly correlated with the number of contributors.
Let me ask you if you agree with this. This is from the NIST mixture study. An likelihood ratio numeric value is not a measurement of a physical quantity. Do you agree with that?
Correct.
Rather, it is a ratio of probabilities in the opinion of the expert assessing the likelihood ratio and is dependent on the specific propositions used to formulate it and also on the individual making the assessment.
Correct. Yes, I agree.
And does the final likelihood ratio depend on the number of contributors you assume?
No, it does not.
It has no effect whatsoever.
It can have an effect. It's possible. It's possible multiple other factors could contribute to the likelihood ratio.
Is it somehow difficult to figure out how many contributors there are in a sample?
I guess I would say that I use my my training, education, and experience in order to determine the number of contributors present in a profile.
I noticed throughout your report, you used the phrase, for instance, with regard to the 1.2 sample, the profile consistent with at least five contributors, at least one of which is male. And for 1.1, you say the profile is consistent with at least 4 contributors. I assume by the word at least, you're signaling that it could be more.
Correct.
And as the number of people to a mixture increases, the difficulty in sorting out that mixture increases as well, correct?
Correct.
I noticed in your standard operating procedure, there's some guidance on interpreting 3-person mixtures. Familiar with that, right?
Yes.
And it says, and correct me if I'm wrong, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
It's possible for them to present. Yes.
Well, it doesn't say it's possible. It says, for example, approximately in all cases, assuming a mixture as a result of the combination of 3 people must be done with caution. For example, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
You said you're referencing my SOP?
Yes.
Is it possible for me to take a look at?
Sure.
Your Honor, I'm going to object at this point. The point that defense counsel is getting at is made in the last answer, which is that the difficulty of sorting out mixtures increases as the number of contributors increases. That's all understood, but that has nothing to do with the probable cause determination. Even if it's difficult, the inferences and the evidence is weighed in the favor of the state. The court cannot weigh the difficulty in determining this evidence. Is it fair for a trier of fact at a jury? Sure it is. But we're now getting into weight issues that are relevant for a jury, but not for this court.
Well, he's implying this is going to be an extended discussion. I have one question which he wants to look at her manual to make sure it's in there. So, and then I'm done.
All right, I'll allow this question, so I'll
Thank you.
overrule the objection. She may review the material and
So could you bring up
question could be rephrased.
one, is it Oliver 148? This is your SOP document, correct?
Correct.
And then go to page 83. Did I read that correctly?
Yes.
And so it's true, is it not, that approximately 70% of 4-person mixtures present as 2 or 3 person mixtures.
It's possible.
Thank you. That's all I have.
Thank you. We've been going for a bit, and depending on how much cross, I'm trying to decide if a break is warranted or if, Mr. McBride, you wish your cross is limited. Again, not trying to say which way you should go. I'm just trying to weigh whether we should take a break.
I will probably be, oh, excuse me. I'll probably be 20 minutes.
All right, let's just keep going, and then at that point, we can take a break. Thank you, Mr. McBride.
Good morning.
Morning.
Is your lab accredited?
Yes, it is.
What does that mean?
So our laboratory goes through a voluntary accreditation process where a external third party comes in and audits our laboratory to a set of standards. Specifically, the ATF laboratory is accredited, and specifically the DNA section of the ATF laboratory is accredited to 2 sets of standards. One is an international set of standards called ISO 17025 for testing laboratories. And additionally, a DNA-specific set of standards put forth by the FBI.
Does the accreditation require that the methodologies you use be validated?
Yes.
The methodologies used in this case have been accepted by courts across the country, correct?
Correct.
Does the accreditation require that forensic biologists like yourself satisfy certain qualification standards?
Yes, we're required to perform competency testing prior to participating in casework. And additionally, we participate in twice a year proficiency testing.
And do you satisfy the competency and qualification standards required by accreditation?
Yes.
And at the time you did the testing in this case, did you satisfy those standards?
Yes.
Moving to your opinions, where on the firearm did you find evidentiary support for the inclusion of Tyler Robinson?
There were several locations. I'd have to refer to my report.
Okay, would you look at your report? And this is, it looks like report number, or exhibit number 30. If we can pull that up just for the witness. Thank you, Kimberly. We had it for a minute here, a minute ago. Okay, if we could go to page number 2, please. Will you just list off the areas of that firearm where there was support for evidentiary support for inclusion of Tyler Robinson?
The swabs of the stock and grips of rifle, the swabs of the butt plate of rifle, swabs of the trigger and trigger guard of rifle with possible ridge detail / smudging, the swabs of the bolt of the rifle with possible ridge detail / smudging, and the swabs of the forend of the rifle.
We go to page 3.
Swabs of the barrel of the rifle with possible ridge detail / smudging, the swabs of possible ridge detail / smudging on the optical accessory.
And page 4.
The swabs of the protected underside of the receiver of the rifle after disassembly. the swabs of 1/30-06 cartridge case, the swabs of 1/30-06 cartridge, and the swabs of 1/30-06 cartridge.
I want to ask you about a couple of those conclusions. Let's look at page 5, please. And calculation number 3, exhibit 1.3, do you know where that swab was taken from?
I'd have to refer back to page 2.
Can we refer back to page 2, please, Kimberly? Thank you.
1.3 is the swabs of the trigger and trigger guard of the rifle.
All right, going back to page 5. And we've had some talk, some testimony from you and some questions for you about the likelihood ratios. What was your conclusion as to the likelihood ratio that you analyzed in this question in calculation number 3?
For this exhibit, the DNA profile was at least 1 trillion times more likely if it originated from Tyler Robinson as the major component and 3 unknown unrelated individuals than if it originated from 4 unrelated individuals.
You say at least 1 trillion times more likely. So it could be a much higher number than 1 trillion. Is that accurate?
It's possible.
But the protocols in your laboratory say you cap that at the number 1 trillion. Is that right?
Correct. We would not report a number higher than 1 trillion.
And it looks like you also did a probability statistic as well in paragraph E. Is that right?
Correct. It's another way of stating the likelihood ratio statistic.
And will you state your findings you made here in paragraph E, and that's on page 6.
The probability of an unrelated individual in the population who has not contributed DNA to the sample yielding this level of support is less than 1 in a trillion.
And same question there. The trillion number, it could be far less than that, but you stop your calculations of the statistics at 1 trillion. Is that right?
Correct.
Let us move to page 7 with regard to statistical analysis calculation number 7. Now, do you remember what 1.3 or 1.13 and 2.1 are?
I'd have to refer back to page 3, I believe.
You could jump to page 3. Thank you, Kimberly.
Page 4, sorry.
Page 4.
The 1.13 is the swabs of the protected underside of the receiver of the rifle after disassembly. And 2.1 is the swabs of 1/30-06 cartridge case.
Now, did you do the swabs themselves?
I did not.
And 2.1 is a cartridge case, is that right?
Correct.
And what's the difference between a cartridge case and a cartridge?
The cartridge is unfired, cartridge case has been fired.
Right. Let's jump back to page 7. And what was your conclusion with regard to, well, first of all, why do you group these two together, exhibits 1.13 and 2.1 in your conclusions here?
They were both mixtures of 2 individuals, and they both yielded a likelihood ratio of the same magnitude, so they can be grouped together.
Okay. It's not that they were tested together?
Correct.
It's just that the results were of the same magnitude, so they were reported together. Is that right?
Correct.
All right. What was your conclusion as it relates to both of these as to the likelihood ratio?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major contributor and an unknown unrelated individual than if they originated from 2 unknown unrelated individuals.
And did you make a conclusion here as well about the a probability statistic?
Yes, so the probability of an unrelated individual in the population who has not contributed DNA to these samples yielding this level of support, so meaning yielding this likelihood ratio, is less than 1 in a trillion.
Nothing else.
Mr. Burt.
The results are in. You are not the father.
The 1.3 sample
Oh, man.
is described as swabs of trigger and trigger guard, right?
Correct.
You didn't do the swabs, but am I correct that you have no way of knowing which part was from the trigger and which part was from the trigger guard?
Correct. So they were swabbed together. So I wouldn't be able to say where the DNA came from.
And that's one of the samples that was degraded, correct?
There were signs of degradation present in that sample, yes.
And you said with regard to that sample, that that was a sample consistent with at least 4 contributors, right?
Correct.
And did what you term the major profile have the largest amount of degradation in that sample?
There was, yes.
And you can't tell us anything about when the DNA was deposited on the trigger guard or the trigger, correct?
Correct.
You can't tell us anything about whether, when you say it's at least 4, it could be 5, 6, or 7 people with DNA on that trigger or trigger guard, correct?
Correct, which is why we have the major contributor that is suitable for comparison, and the minor contributor is not suitable for comparison due to that complexity.
And again, major, minor just has to do with the levels of DNA you were seeing, has nothing to do with someone being engaged in activity that is major in relation to the minor contributor.
Yes, so the major contributor is the majority of the DNA contributed to that sample.
Okay. And some of these samples, you have major contributors of more than one person, right?
Correct.
So for sample 1.1, swabs of stock, you have 2 major profiles, and there are at least 4 contributors on that sample, right?
Can I refer to my report?
Sure. It's Exhibit 30. Plaintiff's 30. Right?
You said Exhibit 1.1?
Yes.
Yes, it was a mixture of 4 individuals. There were 2 major contributors.
Okay. And again, with regard to all these samples, no way of knowing when or how the DNA got on those samples, correct?
Correct.
You referenced another statistic in your report, which is the statistic related to paragraph E, I guess.
Correct.
Is it what's called the random match probability statistic? Or is that something else?
It itself is not a random match probability statistic. It is a way to represent the likelihood ratio similar to a random match probability.
But it's still a likelihood ratio computation, right?
Correct. It's based off the likelihood ratio computation.
And it's still subject to all the limitations we've talked about.
Correct.
Can't attribute it to any person. Can't state it's infallible. Can't state there's a 0 error rate. And you can't state that it is a source connected with any one person, correct?
Right. So part of not being able to state source attribution is the reason we report the likelihood ratio statistic. It speaks to the weight of the evidence. And so yes, we can't do a source attribution, and we report that statistic and address that uncertainty that way.
And address the uncertainty along with the other limitations we talked about.
Correct.
Thank you. That's all I have.
Thank you. Anything further for this witness?
So 4 4 DNA samples,
May this
2
witness be
contributors.
excused.
Okay.
All right, thank you, ma'am. You may step down. Anything further from defense?
4 plus 2,
No, we have no.
666. Come on,
All right.
guys.
Returning
okay.
to prosecution, anything
Muppet
further?
is in the house.
No, Judge, we have no rebuttal evidence to present at this hearing.
I need my coffee's cold. I gotta get a new one.
The state has no rebuttal evidence to present at this hearing. However, before we break, there is the matter that was discussed yesterday with respect to publishing in the courtroom Exhibit 12.1, so that the victim's family can observe that.
Thank you.
Well, now we can't see anything, right?
All right, do the parties wish to be heard as it relates to this briefly, and then court will issue its ruling.
Your Honor, I actually just want to make a quick record. We have advised Mr. Robinson of his right to testify at this hearing, and he is choosing to take our advice and not testify.
Is that correct, Mr. Robinson? And I note that he's nodding in the affirmative. Thank you, Ms. Visser. All right, in regards to the outstanding issue about the publication of State's Exhibit 12.1 to the courtroom only, to persons here, any further input from any of the parties before the court issues its ruling?
Jeff and I, on behalf of the victim, my understanding is you ruled yesterday that you were going to play it, that you did grant our request. So I don't know if we.
Thank you.
Judge, I might simply add, given the court's ruling this morning with respect to displaying exhibits, we may want to make a record with the live streaming folks here that it's not going to be published.
Thank you. All right, nothing further from any of the parties? Okay. Just updating some notes. All right. The court wishes to readdress yesterday's ruling in light of this morning's sanction as it relates to Exhibit 16. The court separately addressed that incident and imposed a sanction on the record. Having considered all applicable public access, fair trial, privacy, and victims' rights interests, the court adheres to its prior ruling. The court finds that temporarily limiting live stream to audio only while Exhibit 12.1 is displayed is necessary to prevent the inadvertent publication of the exhibit from being transmitted to outside the courtroom, and no broader and is taking the least restrictive means to accomplish what is being requested. Accordingly, Exhibit 12.1 may be viewed by all persons physically present in the courtroom, including victim representative Ms. Kirk in her capacity as the victim representative. The same in-court viewing rules applies to all parties and courtroom attendees. And that is the ruling of the court. Let's go ahead and proceed to that, to the state. So could the camera operator let me know when we're switched to an audio only? We are? Okay. All right, and as it's switched to audio only to the state, now my understanding there's no audio on this surveillance on 12.1, is that correct? All right. All right, so let's go ahead and play that. And I'm going to rule that this also applies to the still photographer. It cannot be captured the screen in any way. I noted video recording, but I intend as well as no still capture of any of the monitors during the publication of 12.1. All right. And to the state, just let me know if you're ready. Let's go ahead and play it now.
Okay, so what's happening now is the judge says the courtroom will be able to see the unedited video from an exhibit that was shown yesterday. The cameras will not be able to broadcast it. That's what's happening right now. Obviously, lots of stuff happened in the beginning because of the note that got leaked.
A note got leaked. Man, I'm so far behind.
It's all turkey tom slop, baby. Don't worry.
Well, everybody, this is my shocked face.
So we're on break right now.
They're watching something. So
They're watching something, so we got some time. I want to tell Power. I want to tell Chris a joke. Oh, I have two jokes.
And cheering for Muppet that's in the house somewhere here. Let's cheer for him.
Muppet, 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 Muppet. Muppet.
Oh, so they're watching that right now.
Oh.
And Keats is in the house. Let's cheer for Keats.
Keats. All the Flamingo Mafia. Wish is here. I love you, Wisha.
Wish is here.
All the mods have been doing a great job today. Debbie, big shout out.
I don't know what I'm doing. My group.
We have the best group ever. It's the best. It's the best.
We have some fun. We got Kate too. She's been helping me a lot too.
Yeah. Behind the scenes. Yeah. So you guys want a joke?
Hold on. Did Brandy and Teresa get in today? Yeah, they were sleeping there. I can ask her. She did come
shoot
on
her text.
Yes, she did come on yesterday and said and came on our live stream.
That was so kind of them.
Yeah. Let me check. I know they were sleeping on the ground. So.
Yeah, those girls have been grinding it out down.
Dude, those girls
week.
are badass.
Yeah.
Hey, that's what it's taking just to get in there. So, like, you know.
Well, grinding is an understatement of what they did. You know, they both picked up and like they both have real lives, and we're like, I'm out for a week.
Yeah.
Yeah, exactly.
Yeah.
I just saw some pictures. I don't know where they are yesterday. Them all sleeping on the ground. So I'm pretty sure that they got in. They only allow 14 people in. So you gotta just sleep there all night.
Yeah, they're diehard about it. It was just so cool.
And, and the other thing is, like, I read, because I saw the post Ali was talking about, and apparently they only give like the badges out like 15 to 20 minutes before you enter. So you could be there all night, and if you're sleeping in a line and someone buds ahead of you, then you're done and you don't even get it. So like, even after you get there at whatever time in the morning and stake out all night, you have to be like 100% alert at the half an hour before entering. Otherwise, you might get screwed out of even getting in.
Yeah.
So like,
very true. And I do have a picture of them. Hold on, it's kind of funny. Shout out to Billy, Brandy, Teresa. I don't know if Teresa's in this picture, but
she's not. It's just
she's not.
Billy and Brandy.
Oh, maybe Teresa took it.
Maybe, yeah. The two girls are like on the ground, cuddled up in sleeping bags. Like, look.
Oh my God, that's adorable! I can't wait to see this.
There we go.
Doing the Lord's work. So yes, Wisha. They literally are like laying on the ground and waiting to get in.
That's what it takes to get into this preliminary hearing, guys. You literally got to do what those girls are doing.
That's like Led Zeppelin tickets in the 1970s.
Exactly. You're sleeping on the ground, and there is no beer, party, and loud rock and roll at the other end of this. It's just 9 hours of court hearing.
And they told me it's really hot there. So
yeah. Well, that's because they're there.
Yeah, they're doing an amazing job. They came on yesterday.
They're so fire.
They were fun. They're funny.
They're hilarious together.
No sleep. They're not getting much sleep after they do this all day. They're going on people's live streams. So I really appreciate what they're doing.
Hey, didn't they stop for some Chick-fil-A yesterday?
Yeah.
Yes.
Excellent.
They were funny. They're driving in the car and they were like hauling ass because they're like, we got like an hour and a half or whatever. It was so funny.
And shout out to Steve Cameron. He posted this on his X, so we have a better
Ugh.
understanding of that's not the same vehicle.
Nice.
We're gonna look at the muffler. Is that what we're gonna call it? Exhaust. Sorry.
Thank you for sending those in. That's so cool. That
Okay,
is
so
perfect.
That's totally different.
yeah,
exhaust.
shout out to Steve Cameron on X for posting this.
Good job, Steve.
Yeah, for
Yeah. Nice.
outlining it and for us. See how it has one on the tow truck when they're guiding it up,
Exactly.
and then
And
one
then you
in
can see the dual tip on the other side of the car on the
Yeah.
on the other one. It's a completely different car. We talked about this all yesterday. The hood scoop's not there. The front tails, the front downforce cap is wrong.
Yeah.
And it's funny because when Tyler Robinson's going up the stairs, we covered this yesterday. He looks back at that car like there was somebody else driving it, and they dropped him off almost.
Man, if we were there, Wisha, you know the stuff that we would do.
These girls deserve a season pass.
I want to go. Maybe later on, not now.
No, it's the prelim. If you guys are gonna do anything, do it for the real trial.
This is Steve. Steve, thank you so much for these pictures.
Did Steve drop by?
Yeah.
Sweet. Thank you very
Steve,
much,
you're
Steve.
you're in the chat. Hi, Steve. Thank you so much.
Yeah, thank you so much.
Nice grab on those car pictures, dude.
It's just the way
Dude,
we
thank you
outlined
for
it.
that. We were discussing it yesterday in the chat, and you did it perfectly.
Yeah, we didn't have the side by side like this. I was going
Yeah.
flipping from screen to screen, and we were figuring it out. We knew it wasn't, but this is perfect. So thank you, Steve. Go follow him.
Plus, look at your profile picture. You're a good-looking dude, man.
Is that really you?
He's studly.
Is that really you, Steve?
I think he is. I mean, I call balls and strikes, dude. The guy's good looking. I got a
Is that
face for
really
radio.
you, buddy, with that unicorn head? Is that you?
Yeah. Oh, did you guys want to hear my jokes?
A joke? You got a joke for us? Sure.
I got a joke for you. So, what's Tyler Robinson's favorite drink?
Oh God, we gotta do drinks now.
Yeah, a screwdriver on the roofie.
Oh.
What's Lance Twig's favorite drink? A McFurry.
Oh,
nice.
You're saying that in the chat.
Yes, I got to make Allie laugh twice today. My job is accomplished.
How do I make a McFurry?
McFurry? You take furry and you spray it on the outside of a McFlurry.
But does he have to be holding a McDonald's McFurry or something?
Well, that's a McFlurry.
Well, it's not a good drink because you got to constantly spit out fake hair.
Yeah, I was just gonna say, you roll your ball of ice cream
Put hair in it.
on a cat, and then you stick it in a cup and drink it.
Oh, Jill's just left on fire. A furry navel.
Oh, you said that.
That's a good one.
No one is doing body shots off that.
No, God, dude, that would be like somebody doing a body shot. Body shot off me. That's gross.
Nobody's doing body shots with that.
I gotta do a poll on this Twiggy guy. I think after Andrew Kovac did that video, which he's like, I suggest you all go to Turkey Tom's Substack and look at his pictures. He just said this yesterday or the day before. He's pushing this narrative. I don't like it. I don't like it. I don't like it at all. It's all sloppy.
It's not good. So while we have the time right now, while they're out, I wanted to ask you, because you do true crime, in the last 10 years, hasn't DNA evidence come under scrutiny because of the inconsistencies in some of them, and with some of the
DNA can last for years.
It's become one of those science that's debunkable kind of thing, right?
They're coming back.
It's because people use it wrongly and they rush into it without thorough examination.
When that is
Oh, they're back. Hold on.
live. All right, thank you. Does either party need the benefit of the record?
The state does not, Judge.
No, Your Honor.
All right. So this preliminary hearing is continued to September 1st at 10 a.m. for an in-person hearing. The court will allocate up to 4 hours total for argument. That's encompassing both parties. Does the defense request that Mr. Robinson be physically present for that hearing?
Yes, Your Honor.
All right, we'll make the recording. Thank you. The court appreciates the professionalism, civility, and respect shown by counsel, the parties, and all persons in attendance throughout these proceedings. As there are no further matters before the court, this proceeding is adjourned until September 1st at 10 a.m. Good afternoon to you all.
All right.
Wait, that's
Was that it?
What happened?
What the heck? That was
Wait,
abrupt.
whoa.
Just what
So
did he
he's
say?
adjourning till September 1st?
Wait, whoa. What happened?
They just said they're adjourning to September. They went and watched whatever that item was that no one was allowed to see, and all of a sudden we're adjourned for months. What the fuck was that?
It was a video.
Yeah. Well, my point is, they watched that, they came back, and then they said we're adjourned to September.
Who said we were adjourned?
The judge.
Oh.
Graf.
What just happened?
They adjourned it.
Yeah, I know. I heard that. What? Oh.
Hold on. They did not give a reason. They went, they watched this video off the record, right? Off the record.
Yeah.
They watched the video. He came back and then said they're adjourning to September. Kate Marie saying that she can explain.
Okay, explain. Bring you up? Okay, hold on.
Yeah. Please come up and explain.
1 second. Give me one. Oh, they're like literally it's done.
Yeah.
Hold on.
Wow.
Don't leave this here because you may want to go back and replay the last 10 seconds so you can actually see it. So don't back
Babe,
out.
I'm not backing out.
Okay, I'm not saying you are. I'm just saying
It
leave
just
it there.
went to a different screen, babe. It went to the next
I've
video.
advised Mr. Robinson.
I want to hear it because I wasn't here. And let me pause it for a second. I'm gonna go get Kate. I'm just gonna just give me a second. This is gonna take me a little bit of time because I need to.
Katie, cute picture. Look at you.
Are you flirting with all the women in the chat?
That's his job.
Loaded?
What else are you supposed to
I'm
do
just
when
joking.
you got?
I'm just joking, Scotty.
What else are you supposed to do when you got a unicorn on your head? Like, come on, that's literally he's literally wearing the mascot uniform.
Ah.
That's the wrong person, honey. That you're in the
I
wrong.
know. I'm
DM.
just reading, babe.
Okay.
She's not in here. I have to go send it in a different message, baby.
No, you don't.
Baby?
Just send it in the chat.
Baby.
Just send it in the chat. The chat, babe.
No, I'm sending it to her privately.
Oh, okay. Where? Because you may not have a DM with her.
I know where I'm talking to. It's okay.
All right. Well, wherever you have a DM with Allie, wherever that is, because she's not saying or telling me, she's sending a link there, wherever that is.
But Kate knows.
That's why I'm saying I assume she knows because I don't know. So check whatever that social media is, and she's sending something there for you.
Okay, I'll read that message later. Okay. Oh.
All right. So I guess
Scotty, what happened? How many Scotties are there here?
So just keep an eye out for her.
Why is there 2 Scotties here?
Why? Because we collect Scotties.
How many Scotty? Hello, Scotty? Scotty?
What's Scotty squared?
I'm here.
Oh,
A hell of a lot more of Scotty.
We got a lot of Scotties here. Scotty's in the house.
Scotty.
Scotty.
There's only one Scotty.
Okay, so when she arrives, hopefully I have enough. Maybe I can remove something so she can come here. By the way, this is what Andrew Colvett said. What is the deal with him?
He's outside of his skull right now. They all are. They're scrambling because they know it's a BS case.
Yeah.
I often wonder why Satan continues fighting against God when the Bible is clear that the devil who deceived them will be thrown into the lake of fire and be tormented forever. Somebody should relay that message to our friends overseas. Not applicable here.
All right. Kate is coming
Yeah.
in. Welcome, Kate. Hello,
Kate.
welcome.
Welcome.
Are you there?
Yeah.
Hello?
Hello, welcome.
You just got to mute your
Yep, I just did.
Yeah. Okay.
Sorry. I
That's
was
okay.
watching it on the
Welcome.
TV and yeah, okay.
Welcome,
Um,
Kate.
Okay, so the thing that they just watched was the like edited, zoomed in, running across the roof thing that they didn't allow like the media.
That's what you were
and
watching?
That's what they were watching. Because
How did
remember,
you know that?
So I think it was yesterday, Erica's attorney got up and was like, the family really, really wants to watch this thing. And it was like number 12.1.
Okay.
And we were only allowed to watch 12.4, which was the raw footage of it. That they had to like go back and be like, oh yeah, we need to get the raw footage. Tomorrow we'll be able to see that. That was like from, remember
Oh.
day one, they had the edited one and the judge was like, no,
Yeah.
no. We'll watch
We
the raw
want
footage
we
on
want the
day
real one.
2. Right. And so then Erica's attorney argued that the family wanted to watch the edited thing so they could actually see it. Because on the raw footage, you can't actually see a person running across the roof at all.
Okay. That's what I was like. So what happened at the end now? Did you catch it? Because I had to leave.
Yeah. So yesterday, both sides said that they wanted to provide a brief for the judge before he made his ruling, like basically summing up everything instead of doing closing arguments for the prelim. And so he gave deadlines and page limits for that.
Okay.
And that's what he's going to come back and rule on after all those briefs and everything is done on September 1st.
So
those
basically, this is all over. This is all over, right? We're have to wait till September now.
Pretty much,
we'll have to wait till September for him to rule on it. They're going to be submitting filings based on the deadlines he gave in July and August. And then in September, September 1st, he'll have his ruling. And they're all going to come back in person. And it's going to be, he said, limited to 2 hours per side in case there's more discussion about it. And then he'll rule on it.
So today's done then. We're done.
Yes, today's done.
Wow.
Just noticed, done with Fed slop saying both prosecution and defense is allowed 17 pages each, apparently. I guess that would be 17 pages or a 2-hour argument. Is that what it is? Or
so what they get is the first briefing, they get 35 pages, and then they can rebut, and then they get 17.
that makes sense. So you get half the amount of time with your rebuttal then.
Right, but that's not the 2 hours each.
Got you. So the 2
That's-
hours each would be presenting their arguments, I guess, right? And then
Yeah, so that's on the first.
okay, that makes sense.
Yeah,
That
they
makes
said
sense.
like, yeah, because he was like, yeah, we're going to give this many pages, and then I want to give half, but wait, that's an odd number, but yeah, he was like mathing it yesterday when they were having the conversation.
Okay. All right.
Yeah.
I think that makes a lot of sense. But my question is, if that's what is being discussed, is that a pretty long delay for that? Because like they're not going to be getting back till September. So basically, to figure out and make a ruling on that one issue, they're pushing it to basically the beginning of the fall or the end of the summer.
Yes. But it was initially brought up by the defense. So they're basically saying like, yeah, in order for this to be okay for our defendant, we're saying he's okay with staying in jail until, like he wants this to be fair. So he'll wait.
It's literally life and death matter at this point. You know what I mean?
Right.
And I want to give props to the judge. I mean, honestly, throughout the proceedings, I think he's been fair enough. You know what I mean? Even being in Utah of all places, but that he's going to take that much time to deliberate over this case because of the importance of it. I think that kind of stands out a little bit. And when you explain that, you go, okay, well, he's really going to dive into this at first. You know, it's not just all right, let's speed it to trial. Let's get this over and done with. You know what I mean? And feed it through the system.
Yeah. I'm noticing Death Queef is saying it's actually only 6 weeks. Is it actually only 6 weeks?
Oh, wow.
I guess it is, right? Okay, so maybe that's
Well,
maybe that's not a huge thing. If it's only 6 weeks, it's not too huge. Like maybe I forgot we're already in the middle of
yeah,
July.
we're almost.
Yeah.
September is very near.
Okay, so that's actually not a huge layover.
So, Katie, were you in the courtroom, or were you in Utah?
No, I'm in my bedroom.
Oh, okay. Do you live in Illinois? You don't have to dox yourself, but you live in a Chicago style
Hey,
accent.
no asking personal questions. No, not allowed.
Not allowed.
Midwest.
Midwest. We'll go Midwest. I can tell the accent.
Only if she wants to.
Right. So that's interesting. Okay, so September 1st, they're going to be making. Is it the 1st? It is the 1st.
September 1st.
Yes.
Yeah.
All right.
Cool.
So they're going to make the ruling on that on September 1st, and I guess we'll find out what the next court date is after that.
It's going to go to trial.
Yeah, we'll play it. I'll play it.
Oh,
right
absolutely. There was no way it wasn't going to go to trial.
I'll play what he
Yeah.
said. Let's rewind. Hold on.
Yeah, that's what I was just going to say. Do you want to play that last little bit again?
Yeah. I think they're coming back. Let me just.
Let's see what because it was just so quick. Like I wasn't paying attention right away because I was expecting him to sit in.
Yeah.
And I was expecting it to continue. So he just came in, gave like 2 sentences and bolted, and I was like, whoa, what's going on? Hold on, slow down.
So something happened. I wonder what do you think they saw? Bless you, baby.
What they saw just now?
Yeah, like I wonder what they saw. Like I know they saw the stuff on the roof, but
They
That
saw
was
a
it.
sec.
that was it.
I bet you they saw like 3 people up there shaking up martinis. One guy was smoking a hash blunt.
Okay, let's listen to what.
Stacy, Gibbet 12.1 video transmission may resume. Just let me know when that is live. All right, thank you. Does either party need the benefit of the record?
The state does not, Judge.
No, Your Honor.
All right. So this preliminary hearing is continued to September 1st at 10 a.m. for an in-person hearing. The court will allocate up to 4 hours total for argument. That's encompassing both parties. Does the defense request that Mr. Robinson be physically present for that hearing?
Yes, Your Honor.
All right, we'll make the recording. Thank you. The court appreciates the professionalism, civility, and respect shown by counsel, the parties, and all persons in attendance throughout these proceedings. As there are no further matters before the court, this proceeding is adjourned until September 1st at 10 a.m. Good afternoon to you all.
All right, so that was that.
All right. So 10 a.m. September 1st. Everybody mark it in the calendar.
Yeah, September 1st, 10 a.m.
So before all of that, we were talking about the DNA evidence, and I wanted, since you both have done true crime before, I want you to go over, and Death Queef made a good point in the chat that it was like they can spin it up until they say.
Teresa's trying to call me. Hold on.
Oh, cool.
Oh, woohoo.
Yeah, okay, call her.
Hold on. Hey. No. Yep, me too. I was just about to say you're not on mute.
Stand by, everybody.
Oh yeah, hold on.
All right. I'm going to
It was
ramble on a little
this
bit
one.
here. Maybe go through some
reply to
comments
this
if I can. No coincidence. TV2, Candace is going to be on fire when she comes back. I agree. I'm actually wondering why she chose this time to take off with the SUV release and the preliminary hearing. I think that was a crazy time for her to take off. However, I kind of think that she's going to absorb all this and then come back with some really strong points and start dismantling the case a little bit more.
Yep.
Thank you for blessing me because I'm sneezing my face off like crazy.
So that's everybody just saying wrong stuff.
Hey, honey.
Okay. Yep. You're welcome. You're welcome. Bye. Bye.
So what's the word?
Oh no, she just wanted some information. I'm not gonna.
Yeah. Okay.
I'm not
fair.
gonna say what it was.
Yeah. Okay. Fair.
Yeah. I don't know if you heard me on there. But
You're talking loud. They heard your side. I was trying to pull your mic away
oh.
because you had the volume up so loud on your phone.
It's not a big deal. They're just gonna, since everything's over, they're just gonna go do some stuff. So
Yeah. Well, good time
Yeah.
to try to get some interviews and chase some
Yeah.
other stuff, do some other things while you're there, right?
exactly. So
Okay. So, Scotty, you were going to start talking about forensic DNA and how you believe it's becoming more easier to debunk and disprove and blah, blah, blah. Is that correct, sir? Scotty.
Yeah, I'm here. I'm sorry. I just had a phone call. What were you asking?
No, I was just saying you were going to I believe attempting to ask us a question about
Yeah.
forensics,
So
right?
I'm gonna ask this, and I gotta dip out. I gotta take my mom to the hospital. She's got low blood pressure. Yeah, but I would no. It's fine. It's just her, her cancer. It's fine, dude. It'll take a train to take her out. But so the question I was asking is, over the course of your research by doing true crime, like
Yeah.
what have you found out about, and break it down for everybody so that they know like how unreliable DNA evidence is. And from my opinion, and seeing this whole thing unfold, that there is no picture of no recording of him taking a shot from the roof. Now there's other evidence out there that supposedly says there's a second shooter because there was something that was released, I believe, on X today that one of the girls, Elizabeth, sent me. And so it's one of those things where it's like, if they don't have that and they're relying just on DNA, how unreliable is that?
Well,
you want to go
no.
first?
Well, yeah.
It
No.
depends on what DNA we're talking about too. Also, right? So
Well, okay. So first of all, no one piece of evidence will ever convict anybody of anything. It's always got to be a bunch of things, right? And one thing I've noticed with complications with DNA evidence, and this is what. So first of all, I think it's legitimate. You can rely on it. However, I believe people manipulate it. I believe people don't collect it properly. I believe people don't preserve it properly. And then I believe there's people being paid to alter it in high profile cases like we're seeing now. So
100%.
So that's what I say. Like if you do it properly and you do it the testing correctly, it is legit. But the problem is I feel like that's not happening. I feel
it's
like
manipulative. It's manipulable.
Yeah, well, and honestly, it's manipulatable in a way which is very hard to prove it's manipulatable because it's done in a laboratory locked away where nobody has access to. And that's what we brought up, I think, was in the day 2 of this, how the head, the person who's in charge of forensics study and laboratory for all of Utah was there collecting the evidence. And I just raised a red flag on that immediately. Like
that's 1,000% a red flag. And even the FBI collecting it,
Well,
so,
the
and
FBI
there's been like some cases where like, the law enforcement comes on the scene and they don't even have gloves. They're all touching
that's
stuff.
contamination right there. They need to be in full bodysuits, for God's sakes.
Yeah, like, the white
Well,
Yeah,
no, they
the
don't have to be. They don't have to be in that. That's a little bit much.
Okay,
Right?
It
I'm
is a little
talking
much.
about
I mean,
like that's for like a really horrific crime scene.
Well,
Okay,
yeah, that's if you got blood and guts and entrails hanging from the ceiling, like
right,
Jack the
yeah,
Ripper. Then,
right.
then
But
yeah,
when
we
this
would wear
whole
that.
thing first started, we even noticed nobody's wearing gloves. They're just picking up stuff. I'm like, the whole thing is that whole courtyard in a real, like I say, this is like not real because I don't know what's going on. The whole
yeah.
courtyard is a crime scene. Everybody out, don't touch anything. You see the security guards coming back, picking up stuff, looking for things. It's just this
It's been
doesn't
an S
happen in the
show
real
since the
world.
beginning of it. You know what I
Yeah.
mean? Like it really has. But I want to tell you guys, I love you all. I gotta go.
Okay.
I
Okay.
thank you so much for the entire week. Everybody's been amazing. Thank you for the support, and thank you everybody for doing the research. You guys have been awesome, amazingly
Thank
awesome.
you.
And thank you guys so much for allowing me to be on stage and to be able to like poach questions and stuff like that. So I appreciate all of you. I love you very much for Blanket Mafia power.
Thank you. I'll leave you with power.
Yes.
Thank you,
Yes.
Scotty. Thank
Gets
you.
me going.
Thank you,
I love you guys
Scotty.
so much. I will
Thank you
talk
for
to you
all
soon.
your input on the car.
Thank you very much. I love you guys.
Love you too. Bye.
Love you too.
Bye.
Bye.
All right, go back. I saw a comment I want to
Just
bring up immediately.
Okay. Sorry. So
just the
she's
fact that they didn't use gloves or anything, and then they brought up that they didn't also get exclusionary DNA from any of the um, investigators is
right.
also very telling.
Yeah, because it could easily be their prints there, and if you don't, you need to match that stuff. The real simple.
Right. Or maybe are Hull's prints on, say, the burned up letter?
Yes.
Or, like, I don't know, the guy that Barron's like, I don't know, this all has like Aussie, British, English on it. Like, what's the deal here? And are his prints all over everything? Like, what's going on there?
Yeah, that's a very valid point. I wanted to actually bring up this comment. So, if they were all, see, they also didn't video themselves finding a gun. So we already had something show up or come up, not show up, come up on how an investigating officer's body cam just mysteriously died because they're morons all of a sudden and don't know how to change batteries properly. So I want to know how come all the guys who found the gun, there's no body cam footage from that.
Yeah.
That comment there is reminding us all of how badly the evidence is being processed, handled, the chain of custody, if there fucking is one, excuse my language, if there is even a chain of custody anymore. Like, shouldn't they have body cam footage of like half a dozen guys who found that gun or whoever found the gun, right? So like that's another good point. So
That's
it's
a
like
very good point.
so they're not isolating DNA. They're leaving shells. Remember we heard that? They're left live rounds on the roof. That's freaking hilarious. Now there's no actual body cam footage of them finding the rifle. So like there's a lot of these points that are really key points. Don't seem to be coming out. And I'm wondering if this is something that they have and they're just not releasing it now, or if they never had it and don't intend on ever showing it.
Well,
Right.
and that lady also testified that that wasn't even a roof that they went on where that live round was found.
Right. that is correct.
So hold on.
I mean,
hold on. So the whole thing was when that got brought up is that they were supposed to be on a roof. That was the whole part of that whole testimony.
yes.
They were talking about roofs and that an officer went to another roof and then unchambered around there. Now you're saying, you ladies are saying that wasn't even on a roof?
It wasn't that roof. It wasn't
that
the
roof.
computer science building.
Oh, okay. So what building
She
was
named
it?
the buildings that they were on, and it was not that building.
So she got that fact incorrect, either intentionally or by accident. Okay.
And Teresa said she didn't go in today because she had 44 hours straight, desperately needed sleep.
Oh,
man.
girl, that's brutal.
Yeah.
You are a soldier of light, Teresa.
Yeah.
Thank you so much for literally going down there and grinding it out all week.
Wow.
See that? She was up
Yeah.
44 hours straight.
Can you imagine? I think I've done that, but then I go delirious. Then I can't even like think.
Yeah.
I start singing and
Yeah. I just want to get back to what building that was. Do we know what building that was?
yeah, everybody's asking what building was it.
Do we remember if they said
Gosh.
that?
I would have to go
I'd
back
have
and
to
look
go
at the
back
notes.
and rewatch.
I would have to go back and look at the notes, you know?
Okay.
I was listening
But
specifically for that building though, and I did not hear it.
I'm going to do members
Interesting.
live tonight. I'm going to do some little bit of digging, some research on all these questions that you guys have. If you have any more questions, I will. It's Friday, right?
Yeah, Dunwit's asking if it was the Woolley building. Does that jog anyone's memory?
Hold on.
And Sis Walker is saying computer science, but
Computer science building.
apparently that wasn't the building, the computer science building. That's what they said, but then that was proven not to be accurate. Is that correct?
Yeah, we would have to go back and check. I don't want to say something that I don't know.
Yeah, we're
you
just
know?
we're just asking questions. We're not stating facts here. Just
Yeah.
asking questions, trying to figure out exactly which building this alleged round was found on.
I believe they said the round was found on the computer science building. But then the
Okay.
lady said that they did not go, like when they were investigating, they did not go on the computer science building roof. I
Got you.
believe
So
that's what
that's
they said.
okay. So that's where the discrepancy comes in. Originally, they testified that one of the officers unchambered the round there, and then later in conversation and examination, they stated that they didn't go up there. Okay.
Yeah.
I think Bagley was the one whose testimony said that's where there was the round. That was, remember, because that was
Is
with
that
the
when he
like
lost his
the
battery to
cross.
his body cam? Is that the same time he lost his body cam footage?
There was the cross that like they sort of said it in passing with the unchambered round. Like, and did you know that there was a round on a roof? And we were all like, that was left kind of hanging the first day.
Yes.
And then it came up again the next day. And then a different person was on the stand, and it was a lady who was in charge of something. And she was the one that was talking about where they actually went. And I
Yeah.
believe she did not say
Oh,
that
she's telling me
that
it
building.
was the computer science building. Yeah, I just wanted to go back in our notes and go and double check. So Teresa says it was
Okay.
building 100. Thank you, Teresa.
Okay.
Right,
Okay.
but
So
they
that's what.
didn't investigate it, right?
They didn't investigate it.
Okay. So that's easily confirmed that that is the building that they said, and now we just need to just double check to make
Yeah.
sure that they actually said they went up there and did it.
Yes.
Okay. Okay.
And Steve is saying do a show with me and Don Jeffries today at 5 p.m. Yeah, I didn't have a chance to message you back. I'm gonna message you. Like where? On YouTube?
And 5 p.m. Eastern time. Okay. You have to, if you want to do that, you actually have to text the guy because it's 2:30, and if they're expecting us to bring something, then you
That's in
actually
like 3 hours.
yeah.
I'll message you. Thank you. Okay, so and I'll probably do a members live tonight. I don't know what time. Or we can do it tomorrow.
And we can do it.
Friday or Saturday?
We
What
can
do you
do-
guys want me to do?
We can do. Why don't we just do a couple? You're starting to gain a few more members, so there's no problem.
Yeah,
with
like
doing-
there's some people that want me. They're like, when are you doing a members live? I can do it. I can do it later tonight.
Oh, hold on. There's somebody actually asked about your membership here.
Yeah, I'm trying
Hold
to.
on.
I'm trying to.
That's it was an
Danielle. I think it was Danielle. What did Muppet say? Try and find Agent Ben Schneider. He was meant to be the agent that found the bullet, but I don't think he exists.
Oh,
Interesting. Ben Schneider.
Okay. And did we get? I just want to address the person who was asking about members before we move on to other things and forget that. It was
Somebody's helping them in the chat. It was Danielle.
yeah. Our membership's cheap. It's like $5 or something.
I'm trying to put it lower. I really am. That's like the minimum, but there is a way. I haven't learned it yet. How to make it like just $1. I don't want to. So I'm trying to figure it out. When I do, I'll let you guys know because I've been busy doing other things. But yes, I appreciate all of you. I think I'm gonna jet out of here unless we have something else to talk about, babe. I know we have like the car thing. This is obviously Steve's work here. He did a great job, Steve Cameron. If you're not following him, so you look at that, babe. Look at the exhaust.
Yeah, it's easy to see. He's got dual exhausts on the one on the left, and then he's got the singles on the one on the right.
I bet you any money, Erica Kirk made them like hold off on everything. Because a victim can, right? Victim can do something in this in the state of Utah. I don't know, Kate, if you can help me out on that. I'm wondering with all this, with all these inconsistencies, what's happening here? This is bizarre. Look at this. Look at it's not even the same vehicle.
No, it makes sense.
No.
It's called a cover up.
Cover up.
Well, it's not exactly a unique car either.
No.
Like, and when you go looking for a vehicle after you find out that a guy, you'd already have his name, like, oh yeah, this guy owns this vehicle. Let's see if a vehicle like that was on campus. Like, come on, that's confirmation bias.
Yeah, I agree.
Like, let's see if someone that looks kind of like his build is on campus. Like, come on. Like, give me a break.
I think after this morning and the leak of the stuff that came on the media cameras, everything went to crap. So we don't even know what they were talking about either, right? So yeah. Muppet sent me something funny. I'm gonna share it. We always have to have a laugh too. Can't just always
I've seen
be
an
serious.
interesting comment there regarding the car.
Oh, okay.
Because like when I'm watching here, I don't see the X comments. You're the only one who can see the X comments. So go up here.
Okay.
Right there.
Oh, I know her. So, hi, Riz. So, you guys don't see the lighting where the exhaust is. It's just a different angle. So, you guys think that the defense and the prosecutor both just happen to not notice that there's two different cars and that they allowed the registration not to match as well. Correct?
Well, yes. Like we've got 4 different sizes of Tyler Robinson. There's been so many things that haven't made sense. So, yeah, we'll need to see a little more information on the car before we sign off that that's the car.
I don't think that's the car. I need more.
And you know,
I don't think it's Tyler. There's like 7 of them. I see different hats. I see different backpacks. I see different shoes. I see different heights,
different clothes.
And
So-
what? Like, come on.
So
You know, thank you so much for that comment, though.
No, it's a great comment. And like, you know, we wouldn't be thinking like this if they didn't get caught in so many freaking lies. Like it's been 9 months of like pure lies.
Yeah.
So why would anybody expect anybody with, you know, any kind of inquisitive nature or common sense just to start believing everything just because they said so? It's frustrating.
It's the
because
exhaust. The exhaust. Look at the exhaust in
Well,
the left-hand corner on the
look at
bottom.
look at the
Okay, and
license
then
plate.
yep. Yep.
Look
I'm
at
not even
look at
looking
the
at the license.
color of the license plate.
I'm not even gonna go there. They can just say something, right? But the exhaust is
For
Yeah.
sure.
completely different.
Yeah.
Well,
So like
and the
there's so
way
many
they
things.
kept calling out the distinctive like tire or like wheels or whatever on a V6, like that's standard. That's not even like a higher trim level. Those are regular. Like that's
And
not
what are
distinctive
those?
at all.
And what are those 5 stars on it?
Yeah,
Scotty
it's
talked
nothing.
about it yesterday.
It's
Yeah.
this isn't the upgraded vehicle. This is nothing. Like
No. So is that what they're trying to say? This was this vehicle had a lot of custom work and it was easily identifiable.
yeah, like it would
Is that what
stand out.
No, well, I guess they count on people not knowing what kind of car that is and going, "Wow, that's a fancy car. It must be right."
Where'd she go?
Looks a lot of
There
stock
she is.
there.
Sorry. I don't know
Oh,
what
did you drop her by
By
accident?
accident, I was trying to add a picture. Are you there? Sorry. Are you there,
What?
Kate?
Yeah.
Oh, okay.
Can you hear me?
Okay, sorry.
Allie accidentally dropped you out and brought you
Sorry.
back.
I was trying to
Oh,
add
it didn't
I was
disappear
trying to
from
add-
my screen.
Okay, because
That's
I
cool.
did it really fast. But
Um,
you want to know where we're at?
Speedy.
This is okay, so let me just remove that from studio. We got
This
this.
mountain of evidence. It's slumping again. It's covering our shoes.
This is courtesy of Muppet I mean, sometimes when I'm live streaming, everybody will send me stuff like something funny. This is funny.
Look at this mountain of evidence. It's slumping again. It's covering our shoes.
Oh my goodness.
Brutal.
But do you know what we do got, babe?
Mm.
This is what we got. I'll try to bring it. Kind of can't bring anything up on this darn
You got
stage.
way too many things in there. Look at all the
Okay,
things
well
you
we got this.
You got like
We
40
got
things
this.
in there.
Okay, I'll start deleting stuff. You know, I don't know who made this. I forgot.
I'll be
Darn
right
it.
back.
And then, oh man, I don't know who made this either. It's on X somewhere. Just different discrepancies of even the hair in the back, and the hat, and the hat. It's
Yeah.
just the neck, the neck, the neck.
Well, and did you see the texts? I called it out in my brief this morning. The way that the texts are on the phone,
Oh,
that's not how they work.
I have a picture of that too.
Like they
How
don't
convenient.
actually go up over the banner at the top. That's not how iPhone texts work.
Yes. And I'll bring up a picture. Hopefully I
They
can bring
also
up something
don't
here.
repeat the same day. Like it shouldn't say Wednesday and Wednesday.
Okay, I see what you mean. Yeah, and there's another thing too. I don't know if you've seen it. You probably have. A lot of people are posting stuff. They're doing great work. I think this one was from Sam Parker. If I can bring it up. Oh yeah, here it is. Can I load anything on this darn freaking thing? Hold on. Where is it? Oh, here. There. How convenient. This is by
Yeah.
Sam Parker. The left-hand side of the screen, the date's
Right.
the time's gone.
Yeah, and that broken pixel that shows pixels over it, that doesn't make a whole lot of sense.
Yeah.
Yeah.
Like, oh
But
wow, we
look,
got a broken screen right where we need to see the time.
but look at the left-hand side where it shows the parts that they don't want us to look at, where the conversation supposedly didn't start until 11 o'clock, but you can see the conversation clearly did. Why does it say Wednesday twice?
Yeah, somebody
Conversations
mention
don't
that.
work that way.
No.
And look at the top. Why does the bubble overlap the banner? That's not how iMessages work.
Oh, good eye. Did you post that?
They
You should post that.
it's in my brief.
Okay.
I'm bad about posting things. I usually just make the document and post it in like Dankster and
So-
Baron.
Do you see the top there? Did you already send that to Danks? I would send that. To see the top
Yeah,
bubble?
I mean I sent, yeah.
The top bubble is over the line. And how convenient the glass is broken at the top. And there's two Wednesdays, yes. Does it say that? I
Yeah.
can't bring it up close, but does it say the time, the exact 2 timestamps too?
I think the other one is at like 4:30.
Yeah.
Yeah.
So I
And
think
it's like saying kissy kissy something. I think it's not actually. I don't think that said Tyler before. I think he changed the name to Tyler, and it was a text to somebody else first. That's
Sorry, is this a Sam? What kind of phone is this? It's not an iPhone.
Yeah, it is.
yeah,
It is? Okay.
Yeah, it is.
Yeah,
Alright.
but
I
it's
just wanna
old.
bring-
I went back and looked at my old texts. That's an old, like it's a not updated from like 2025 or whatever. That's what it was.
Gotcha.
I'd just like to bring up the point. I don't think I don't think they made up these conversations and damaged the phone, because it makes no sense to do that. You'd either just damage the phone or make up text messages. The only way it would kind of make sense to me that they did both, that and this would mean that they are all complete and utter morons, is that they damaged the phone hoping that it would take out whatever information, and then realized, oh my god, it didn't work, and then had to doctor stuff anyways.
Yeah.
That's like freaking the Three Stooges running an investigation. Now, I'm not saying that, that didn't happen. Of course, anything could happen. But I think it's more likely that it's one or the other and not both.
You
if that
can
makes
call
sense.
you can call the company wherever their phone is from, and you can print out all the stuff properly. Why aren't we doing that? Why are we showing a picture of a phone? No, I want the whole entire thing printed out, please.
Well, and they even said that they got the Cellbrite like logs. So why aren't we using that?
Yeah.
Like this is
Everything's
ridiculous.
falling apart, Kate.
No
My
kidding.
my only thing I can think of, actually, now I was just thinking about it. Maybe his phone was already damaged, and that's just the way it
Right.
was. And then they just edited. Because the only other way I could see them damaging the phone, you'd want to damage it in a way where you could still use the screen, which means you'd have to damage it in a very specific way. Like to make that crack right there, I would take like a sharp object and then hammer it into the screen, but not too much that you shatter it right through.
Babe, who has
What?
cracks like that on their phone? Usually it cracks, right? Like shatters. What's that? It's like somebody went bam with a screwdriver.
That's exactly what I'm saying right now.
Screwdriver.
That's exactly what I'm saying right
That's
now.
from a screwdriver.
Like they
I
put-
wonder how his DNA got on a screwdriver.
Aha.
What screwdriver?
We have
Oh, I
4.
don't know.
Wait, what was the on the was it the rifle that had 4
prints.
and then just two was from Lance and Twigs? They don't know the other one? 4 contributors, she said.
Right. 2 major
Or-
contributors and 2
Yeah.
unknowns or something.
Exactly. But look at this cell phone. Doesn't that look like somebody went bam with like, a sharp?
Mm-hmm.
Because if you drop your phone on the floor, that doesn't happen.
You
That
know,
doesn't happen.
well, unless I don't know. There's a million different reasons how it could have happened like that naturally. That I don't even. think
Sure.
we
It
should
was
spend
laying on a Lego and he stepped on it in that one
Yeah,
spot.
like there's 1,000 different ways. It could have fallen on a rock. There's a million different ways that could have
Okay.
happened, and I don't think
I don't-
theorizing 20,000 ways will make
Right.
bring us any illumination to what's going on.
Right.
I think we just keep it really simple. It's either damaged on purpose or not. If it was damaged on purpose, what did it do? If it was damaged by accident, then it's accident. It doesn't matter. So the
Right.
whole thing is we got to just not go too far down that rabbit hole. So it's just like if
Yeah.
it was damaged on purpose, what's the reason?
Reasoning,
Especially
yeah.
since it
Well-
looks like they edited them anyways. What's the point of damaging it then? Right?
Well,
just
she just showed that the bubble at the top doesn't line up. So
But that's my point,
Right.
and that's
I
what I'm
think
getting
the
at.
phone was already damaged. I think the phone being damaged is like, yep, see, this is his phone. He has this thing on his phone. His parents knew his phone was damaged. Everyone knew his phone was damaged. And then they're like, but look at all these texts on what is obviously his phone because it's cracked. This is his phone.
yes,
Yeah, and see that makes more sense to me. That's not mischievous in any single way because it doesn't make sense. Why damage the phone to try to alter it to hide metadata when you're just going to edit it anyways? Like it's so stupid to me. And I think that's
The other
literally.
thing
Go ahead.
the other thing I noticed when I was trying to edit the photos to make it look like easier to read is the first one, this one, has fingerprints all over it. Like it was really hard to edit and like not have weird fingerprints kind of showing up.
yeah,
And the other ones were much cleaner. They didn't have like weird shadows and things like trying to alter as much when I was trying to change the coloring and
Mm.
stuff.
very interesting. Man, this is bizarre now. Okay, what do we got here? I'll tell you what we got. This is what we got. Where is it?
What are you looking for? There's so many
Um,
things you have on the stage.
I'm looking for that. I'm looking for something to break the just to have some like, what is this? Shout out to Wisha that sent me this. Get in, loser. We're going to UVU.
Nice. All you need is like George Zinn in there.
Oh
Right.
man. This is where we are. This is it. And
They don't look anything alike.
no,
Come
no,
on.
no. I mean, but I don't think he was the one going up the stairwell like people were saying that he is, right?
Neither of
I
those
don't-
guys went up the stairwell.
I think there are other people.
No, they just they got his name and they were like, hey, let's find some guys that look a little like this guy. The same thing with the car. Oh, he drives
Yeah.
this car. Let's find some cars that were on campus that look like that car. Like that's confirmation bias. That's not doing an actual investigation. Come on now.
Exactly.
So now we gotta wait till September 1st. Man, it's gonna become like 1 year since Charlie.
Yeah, and that's when they'll drop the biggest Fed slop at all. They're going to try to hype up the 1 year anniversary of him passing. They're going to try to probably feed us a whole bunch of extra Fed slop. You'll actually probably see a lot more coming out about Judeo-Christian values. You're going to see a lot more shit.
Bible verses are gonna come out today.
Yeah.
Andrew Colbett's already doing it.
Yeah. And you're going to see a lot more attacks on people making content as well. So if you have creators that you support them because they're going to need it.
Yeah.
But
We
they
got to
want
get this stuff out.
answers.
Yeah. We
They
got to
want
get this
all
stuff
the
out.
answers. They have so many questions.
Yeah. We gotta keep pushing. Okay. Because this is what we got. Right.
Yeah.
Right, babe.
So when you're a government
Um,
witness and you can't tell the truth, all you got to do is put on a freaking bear hat, and then you can put on Furry by Fed Slop and Erica Kirk.
Oh man, this is where
That-
we are.
That is my advertisement for Furry perfume, brought to you by Fed Slop and Erica Kirk.
Thanks, babe. That's so good. That's so good.
How funny would it be if how funny would it be if everyone that showed up on September 1st showed up in a maroon shirt?
That'd be
Oh my
hilarious.
god, we should all go. Is it going to be like another preliminary hearing? Is it going to be the same?
That's what it
It's
is.
just
It's
going to
an
be a
area-
4-hour. Yeah, it's the end of
Yeah.
the preliminary hearing, but it's going
Just
to be a
one day?
4-hour thing. But that'd be
Just
so
one day?
funny. Yeah.
Not even
Yeah.
a day.
Yeah.
Oh,
Half a
crap.
day.
Not even a day. Not even a day. They already said how long it's going to take.
Okay.
They gave us the time
Yeah.
frame of what they're going to do, how long each side is able to discuss, and that's what it is. But like if people are going to go on that day, heck yeah, everybody go in maroon shirts with a black
Right?
backpack and a different black backpack
We should
and
do
different
it.
hats.
That'd
We
be
should
so
all
funny.
go with different. Yeah, I'll wear maroon and I'll wear like the blue backpack, and then you will wear the
Well, no, you wear shorts, and a maroon shirt.
Yes.
I'll wear pants.
jeans.
Yeah, and then I'll wear a black
You'll be
shirt.
so tall. Watch how tall he is. Stand up, baby. You gotta show everybody how tall you are.
We always do. That.
Everyone's
I
got to
guess
wear
we
Converse.
But I have high shoes on right now to make myself higher. I'll take them off. This is how short I am. I'm gonna take them
Well,
off. I'm gonna take them off.
The funny part is what you don't realize is I'm sitting and Ali's standing.
Yeah, I'm standing right now.
I'm sitting.
He's sitting. Okay, now you stand. This is okay. This is how tall he is.
Holy
I'm
shit.
I'm a mini me. Yeah, this is what it is. Yeah. So now I'll put
How
my
tall
shoes
are
back on.
you?
Oh, I'm like 5'2",
I'm
Oh,
6'6".
wow.
and he's 6'6".
Wow.
Wow.
Well, 6'5". I think I shrunk an inch when I hit 40. It happens when you get old, so don't age.
So we did the Erica Kirk hands. Babe, show the hands because my hands are really tiny too, right? Like I
This
wear.
never, yeah,
wear-
this never shows up well every
Okay.
time we try to do this because that's the wrong hand. You need to give me your
Oh.
other hand.
I'm sorry.
This never shows up well on video as it does still pictures because like you got to really go like this. So like we're palm to palm, right there. Now
Oh
look.
my god.
Yeah, and then now I'm gonna do the one. Give me your other hand. Now we're
What?
gonna do the one where she goes like this.
You got to do it the same hands.
Okay.
This is why it never works.
Okay. So then.
So you can just show it like this. Big difference. Her fingers, her hand basically fits in my palm, and then
Yeah.
my fingers wrap around. And that's the difference between Erica Kirk and Charlie.
Yeah.
So that's how we knew when they released the coffin video right away back whenever the heck that was. Allie and I jumped out and said the whole thing was fake, and everybody's been riding with that ever since we first said it.
Yeah.
And we're the ones who proved it. I was the first one to say that was a staged event because Erica actually had a microphone mic'd on her because you can tell it wasn't from camera audio.
Yep.
And the reason why I said that is because when she bends over close to the hands, you can hear the mic rustling.
Yep.
So that means
Mhm.
it's pinned to her and it wasn't a camera phone mic. So we said that like what, October last
Yeah.
year?
We went on Mr. Lecko's and we did the hands. He goes, I don't know what you're talking
Yeah,
about. And then when we showed like how tall he is, and I don't know how tall Erica Kirk is, okay, but I think her hands are tiny, but some people say they're thick. I don't know. But Charlie's hands are massive. Like he's 6'5", I believe.
Yeah.
And so's Chris. So if we're going by a person's height, the hands in the coffin were so tiny.
Well, it wasn't even that. You forgot that we actually just looked at their wedding picture too.
Oh yeah, we did.
That's the big seller of the whole
Yeah.
thing was the wedding picture that they
Yeah.
had. Because you see Charlie standing and he's like this and Erica's hand is over top of his.
Oh yeah.
And it's like obviously way freaking small. And then we looked at the video of what they made with the coffin and all of a sudden the hands are the same size. So we knew that was all staged.
Yeah.
Considering they released it right away, we figured it was a PR stunt in order to help ingratiate Erica with the masses. But then after it came out that almost everything she ever does was staged, it had no appeal anymore. It was just like, well, that's all fake. And is anything
Yeah.
real? Is your grieving real? There's no tears yet. It's been
And
4
we don't
months.
even know where his body is. But Elite Asset said something really good here. If they have mountains of evidence, then why is Andrew Colvett asking so many questions? Love that. I love that.
They don't have mountains of evidence.
I love
Otherwise, they
that.
drop it here and there to shut us up.
Ali, were you able to take another look at the road mic in the back of the SUV I sent you? Yes, I did. And I want to bring it up like on a members live or something, or on another live stream, because obviously we're talking about all this other stuff right now, right, Court? So yes, I have. And thank you so much. Just tell me when we should do this. We're going to do another rundown of the SUV again, because I think we should do a recap of that. We should. Thank you. Yes. So I might do a members or I might do a live stream. I'm not sure yet.
May I suggest?
Tomorrow, members?
Well, it all depends. Before you make any schedule about members only members later tonight, maybe we should end the stream. You should reach out to Steve to see what
Yeah.
he was talking about, because
Yeah.
that's 2 hours from now. And if you
Yeah.
need to build an entire show, then we have no time.
Okay. Yeah. All right. Yeah, but members you can pop out at any time. Anyhow.
Yeah, but as long as that's not too huge, yeah, we can do one tonight. We can do one tomorrow. I say we do a couple in a row, because
Yeah.
we've gained more members, so we should do a couple episodes.
Yeah. Thank you so much for everybody becoming a member. And if you're new to this chat, I really appreciate you. We are the Flamingo Mafias. We do actually research on the spot. I have a lot of people in the chat that help research. I have Kate now in the chat helping as well. I offer anybody that has any kind of, information or work they've done to come up and talk. Because that's
And
what
share
this,
it.
yeah, and that's what we do here.
Yeah, that's what our channel is all about. We really involve our community, probably more than any other channel out there. And, the viewers are our biggest source of strength to help channels grow and to find out information and to find the truth. And we want to showcase as much of that as we possibly can on
We may be
Ali's
small, but we're mighty. And the reason why I love flamingos so much, because they're my spirit animal. Stuff happens to me when I meet them. Don't ask me why. And I feel like they flock together, just like what we're doing as a community right now. We are all contributing to this case. So let's go and put out the info, because it's falling apart for TPUSA. It really is. I feel like it is. Anyhow, I think we're done for today, right? Yeah?
Yeah, I think so.
Yeah. Thank you so much. Thank you so much, Bella. Balima?
Thank you guys for having me.
Balima. Thank you. Thank you for coming.
Yep. Thank you, Kate. And thank you, Cindy Yates' team.
Thank you for having us. You guys are
Yeah,
awesome. You do great work.
You're a trooper.
Thank you.
You held
You
out
are
all
too.
week, and thank you for your help for putting the updates in the comment section on the case. And this is it. Now we have to wait till September 1st. So we
Yeah.
have a lot of work to do, everybody.
Yeah. So doesn't mean time to back off. This is time to put the heat on, keep digging harder. We've got 6 weeks, but see what we can come up with in 6 weeks. Maybe we can throw some evidence
yeah.
at these people that they can't ignore. So,
So-
let's look for that smoking gun, guys.
So with that, thank you, Kate. Thank you, Cindy.
Yes,
Thank
thank
you,
you.
Ray. Thank you, Scotty. Thank you, Tornado Alley. Thank you, all of you in the chat, for helping today. We are signing off. And thank you, Teresa, also.
Yes,
And
thank you.
Brandy.
Brandy, Billy, Diligent. Thank you to
Diligent, yeah,
Diligent
yeah.
as well. Teresa, you're a gem. Thank you.
And Baron, he's been doing incredible work.
Yeah, Baron's actually been crushing
He's
it.
crushing it.
Like, I think, between you and Baron, the last month has been freaking ridiculous
Yeah,
with the content.
yeah,
It has been absolutely ridiculous.
I try to send him anything I have when I get it immediately. So, shout out to Baron.
Shout out to Daisy. Shout out
Daisy,
to Daisy.
Coach Colin, all the people that are doing great work, like Mr. Lecco, and all the guys are doing great stuff. Real Bays is doing stuff. So this is where we are. And I'm going to sign off, everybody. So thank you so much for coming. Thank you to my guests. Please follow them. If you haven't, their link is in my description, and I will see you tonight. Oh, somebody's sending something before I go. Thank you so much. Oh, I got to come back on screen. Hold on. I'm so grateful for your timely lives. What a team. Candace had a blowout video about a month back. I was looking and waiting for live response, and it was you. Oh, thank you so much, LaRosse 6078. That was very thoughtful.
That's a great comment.
That's
Thank you
great.
so much
Thank
for
you.
taking the time to send that. We
Thank you so
appreciate it. Thank
much.
you very
I
much.
really appreciate it. We're doing incredible work. This is the Lord's work. We're getting attacked. The researchers are getting attacked, getting, the D word. I don't want to say it, but yeah, we got to keep pushing, because if people are doing that in their own country, these campaigns to attack, that means that we're on the right track. We are on the right track, because there's something wrong. You wouldn't start a campaign if there was nothing wrong, right? So let's keep going. Let's keep pushing and fighting for the truth. So thank you so much for that again. And yeah, we are signing off. I will see you tonight. If I do something with Steve, I'll let you know. I'll put up a link, and then I might go live tonight on a whole bunch of things, and tomorrow and Sunday. I usually go Friday, Saturday, Sunday.
Yeah, weekends are usually busy.
Yeah, I go Friday, Saturday, Sunday, all night, all day, all night. So thank you so much, everybody. Again, I love you, my Flamengo Mafia. I love you all. And I will see you later. Christ is King. Jesus loves you. Keep fighting for the truth for Charlie. Bye now.